Writ petition allowed. I do. Nine. Yes. Okay. Item number nine.
8 and 9.
Only nine. Sorry, 15 or 15. 15. Item number 15.
Let's say I am for a petitioner, sir. This pilot method was me pick in the immediately on next is 24 after 24
Okay. As agreed by learned advocates for both the parties, this is a list of matter.
on let's say 28.
On 7th November.
Last part, this court will not be sitting here.
Okay, let's see.
Right.
As a pilot.
Yes,
May I
Seven-
please,
as a partner.
my lord, with the restraint, my lord, I'm sorry to submit, my lord, regarding item number 23 and 24, my lord. It's a part-heard matter, my lord. So I have personal difficulties today, my lord. Can it be taken up in the first week of November, say on the date of 4th November, my lord? I'll do it, my lord. It's a commitment. Third, fourth, whatever your loss.
So your part you have completed.
No, I have
Let the
the,
other side complete their part. You can reply on next day.
that, but only my adjustment date will be 3 and 4. Let them do, my lord, no issue. They can do it today.
They can do it
Yes, my lord.
today.
No, I don't know, my lord. So for my part is concerned, I have to give a reply, my
No,
lord.
you have completed.
Not fully, my lord, because I have to show that. as well.
Committed that you have completed.
No, my lord. With all respect, my lord, I have to show the legal provisions, my lord, the laws as it stands. On that note, it was adjourned, my lord. So on third or fourth, I'll finish it, my lord. We both can finish. it.
Okay. On the
We'll finish it,
by
madam.
Mr.
That's
Zetkamar, learned counsel for the petitioner. You inform the other side.
I'll definitely. Actually,
Sir,
they are not sure who is coming, but I know Diganto may come. I'll inform him, my lord. Sure,
Press
my
will
lord.
listing the matter on 3rd of November.
3rd of November, my lord.
Sure.
May I please, your lordship?
Much obliged.
Item number 25, lordship. This matter may come after week, lordship. Today we have some difficulty.
Press test cannot to learn it counsel for the petitioner. With consent for the other side, press will listing the matter
A week, lordship.
after a week.
If possible, a date may be fixed.
In the month of November, then, not after. On
Okay.
18th November.
Deeply obliged.
Maybe. This so have taken this note.
8 and 9.
8 and 9. On 27th of
28.
What is the Is it a part-heard matter? No. Okay. On the pair being made by Mr.
P. Solomon on behalf. A. Chetty on behalf of the case.
Yes, Secretary, learned doctor preparing on behalf of Dr. P. Sharma. Respondent number 9.
5.
Respondent number 5. With consent from the other side, you inform the other side.
Yes, yes. I present.
Press for listing the matter on
22nd.
On 30th, 30.
30.
30th October. Then on 31st October.
20. 20. 20.
27. 27.
May I please, I beg to mention item number 22, my lord. Madam, may I be taken after a week, my lord, on 6th of November, part-heard matter, my lord.
you were appearing for.
Petitioner, my lord.
Pardon?
Petitioner, I am for the petitioner.
Petitioner.
Yes,
Your
ma'am.
name, please.
K. Kolita.
Your name is not there.
K. Kolita, my lord, on behalf of ISPK.
Item number 22.
Yes.
Okay, Mr. K. Kolita, learned counsel, if it is not behalf of the ISPK. Learned counsel for the petitioner with consent from the other side, press for listing the matter on
6th of November, my lord.
6th of November.
Part-heard. Obliged.
There.
My lordship, the respondent counsel has mentioned item 21, lordship.
21
21 Lordship. So finally, matter will be taken after a week, Lordship.
after a week. Mr.
NZ Chaudhary.
N.Z. Chaudhary, learned counsel for the petitioner. Learned counsel appearing on behalf of the Air Bhuyan.
Yes, Lordship.
Learned counsel for the petitioner with consent on the other side responsibility. After a week.
Week, Lordship. Okay.
Chair.
Items for admission. Item number 1, Parthad Mehta.
May I please, Lordship? My lord, as per order dated 21/8/25, my lord, we have received 50% of the provisional pension now.
50%.
50% they have paid.
Then, is this matter ready for final hearing?
My lord. My lord,
Are
we
you
have
ready
filed,
to argue the matter?
my lord. Fix another hearing date, my lord.
Another day? Another day.
And last week of October.
First week of October.
Or any farm that, my.
Heard Mr. T. Bora, learned counsel for the petitioner. Yes. Counsel for the 5. Mr. Solia for respondent number 8. None appears for the rest of the respondent. Mr. Bora, learned counsel for the petitioner, said, pursuant to order of this court dated 21/8/2025, the respondent authorities have been granting provisional primary pension at the rate of 50% to the petitioner. Mr. Bora further submits that the matter may be set for hearing after a week. There is according to law, this is the petitioner matter on
13th November.
13th of November. Published.
Item
As a
number-
part heard, my lord. Published.
Item numbers 2 and 3. Parthad Mehta.
I at least have you the accepted at the it's extending on can be put at the end of the
you have been recently engaged
Yes, ma'am.
as BTC counsel. No. Today you have been appointed, tomorrow someone may be appointed, whether the petitioner is bound to furnish copy to each and everyone.
Worship, actually earlier BTC council have changed now and now at present the appointed and
Here ones are not, they cannot appear. So there's an entire new panel of.
new panel. Whole panel is changed. So let it be come on 28th of this month or 4th of November as matter may be kept as Parthad.
Furnish a copy to her.
Yes,
Her Miss A. Pudar Borwa, learned counsel for the petitioner. And Miss
Madam.
Arda, the learned counsel appearing on behalf of Miss Mr. A.K. Bhuyan. A.K. Bhuyan. Ms. Thus submits that Mr. A.K. Bhuyan is recently engaged as the counsel. And he is not ready to argue the matter today. And tries for listening the matter after a week. And she also tries for directing the search party a copy of the petition to her. Here is according to law. Pudar Borwa, learned counsel for the petitioner to party a copy of the petition to his class during the course of the day. Yes, it's a list the matter of
18 November.
18 November. Kept as Parthad, madam.
Number 4, Parthad Mehta.
May I please, your lordship? Your lordship may kindly take up the matter after some time, lordship.
Leave it.
Item number 5.
None appears for the petitioner on call, however, sir. Thus, started. Certain counsel would have to hire the court present. This is a matter after which the event of subsequent honor visit subsequent order shall follow.
Item numbers 6 and 7.
Magnet. In this case, that one.
Other bodies coming,
Who is your senior? Who is your senior?
here, I
Item number 10. 10.
None appears for the petitioner on call. However, it's your name, please. Learned counsel for the respondent number 1 and 2, and Mr. Soliaba. Respondent number 4 present. The event of subsequent honor present. Of the
Item 7.
Your Lordship, it's been more than 605 days that I've been out of job. And they were asked to file the counter affidavit, and it has been around 126 days that they haven't filed the counter affidavit as of now. And Your Lordship, the principal, who is one of the co-accused, is likely to retire this 2026, and the audit officer has already retired. So it considers a serious threat to this particular case. They have filed one written submission, WS, in the trial court, which they have contradicted their own statement. If I may furnish it to you, Your Lordship.
who is for the other side?
Lordship, they have not been appearing for quite some time now. The matter has already also been asked to be, what was the first order? The matter was also played into a mediation, but I am surprised, Lordship, that I have been accused of misappropriation of funds and embezzlement. How can it even get into that sort? An interim relief may be provided, Your Lordship. It's been 600 plus days I am out of job, Your Lordship. The department is now praying for an amicable settlement, Your Lordship.
Nothing. I will take it out after some time. You will inform the council.
Sure, Your
after
Lordship.
some-
Much obliged, Your Lordship.
Item 12.
May I please, Your Lordship, matter pertains to completion of appointment, Lordship. Kindly peruse page number 33. It is recommended by the DLC, Lordship. But despite recommendation, SLC has not, the matter has not been placed before the SLC, Lordship. Page
number
33.
32.
Page 33. Serial number 2, Deepmani Bora Hazarika.
the direction was of this court to place the matter before the DLC. And DLC has recommended her name. Now, invariably, it has to be placed before the SLP.
SLC lordship. But lordship, before going to the merit of this, before going to the merit of this case, I would like to submit that the detailed access is there, lordship, and the labor growth theory will cover it. For December.
Delay
And
access,
lordship, on the basis of that judgment, lordship, the new OM was placed by the personal department, lordship, wherein lordship, one, some SOPs were prepared by the government regarding the competition.
That's all right. Now, let the SLC take a call on this.
Lordship, now lordship, what happened, lordship, now they challenge the new OM, lordship, the reviewed OM. And before adjudication of that OM, lordship, they challenge, lordship, the reviewed OM, lordship, on 18 September 2024. So, review of the skills. Page 37.
Yes.
This is the new OM, lordship, wherein the new the Supreme Court recent judgment on the basis of that judgment, lordship, what SOP was prepared and consideration for completion of appointment, now it is no more. And therefore, lordship, to settle the matter, lordship, listen, I have some so one thing, the personnel department issued a notification to 7 popular daily newspaper of the state, wherein categorically stated that those are the petitioners pending their cases challenging the OM laws. They have to submit their details before the concern of.
in terms of that notification, I have already submitted my details, lordship. I have submitted my details, but what happened to my this recommendation, lordship? It is recommended by the DLC, and they have not challenged that recommendation till date. Without challenging, without interfering that order, how can they?
No, if he has already applied in terms of that
Lordship.
new SOP,
In my
then
case,
SLC
he have to
considered a
wait,
matter.
my case may be placed before the SLC. Then SLC take the decision, whatever they take.
till the adjudication.
My
of this
limited fair before you.
memorandum, lordship, it is office memorandum of 2024, lordship. No further proposal may not be considered by the SLC.
Despite
Because
to that
this is the-
notification, lordship,
this is the
several cases are disposed by this ordinate bench of this honorable court, lordship.
all cases.
Kindly peruse
disposed.
this order, lordship.
All the cases are disposed on that
The-
count, lordship, the new SOPs were prepared. Wherein, lordship, I submitted my.
That's why that notification was issued,
Yes,
lordship.
the-
And I have accordingly submitted my all details.
One by one.
The petitioner submitted his details. He have to wait for disposal. Everybody's are
No,
waiting.
no. Sir, Goswami, you see, we cannot keep this matter pending now. We dispose of this matter, only observing that the matter may be placed before the SLC. SLC will consider it in accordance with.
That's wonderful.
Lordship is correct. Lordship is correct. But, as per lordship, as per the settled principle by the labor authority body.
No, we will not make any such observation. You will
Lordship,
do.
in the earlier cases, lordship, by this honorable court, this observation was made. Delay part regarding the delay access.
So far delay in license part is concerned, lordship, earlier order may reflect it. Lordship, kindly see page.
So, let the SLP consider the entire matter in view of the settled principle and also in view of the decision of the Supreme Court.
Lordship, that's the difference. That's
So, we are disposing of this.
Lordship.
Lordship.
May I please, your lordship, my lord? My lord, in response to the, my lord, affidavit in opposition and affidavit, another, my lord, affidavit, additional affidavit was filed by the, my lord, respondent number 1 and 2, my lord. And in response to their affidavit, my lord, I have filed one affidavit in reply, my lord. Lordship will kindly have a look. Turning page 110, my lord, of my affidavit. That was filed on 16/9/2025. What happened in this case, my lord? There was an inquiry, my lord, which was carried out by the, my lord, respondent authorities, and no prior notice was sent to us, my lord. Lordship will kindly come to page 111, my lord, para number 4. I read the, my lord, specific paragraph, my lord. Everything shall be clear, my lord. Turning page 111, para 4, my lord.
Upon you have gone through the affidavit.
Lordship, my lord, would like to say one thing, my lord, that on the last occasion, Lordship had asked for the report. The report is with the Lordship regarding the condition of the school. So Lordship had seen it. So last time when I filed the affidavit, Lordship wanted to go through the report, my lord, that the photos and everything, my lord. So it was in a dilapidated condition, my lord. So
My lord, I am referring your lordship to page, last page of my affidavit.
One by one.
My-
Second from second. Yes.
therefore, my lord, I would like to go through the reply then, my lord, what he has given, because
Yeah. No, when did you receive the copy?
there was vacation, my lord.
My lord,
So,
16/9, my lord. It was all
it
along.
was,
my lord.
Other day, my lord, I'll go through it, my lord.
My lord, there-
Otherwise, the report is not already with your lordship, my lord, because last time what I had already made my submission on the last occasion.
Lordship
and
will
the-
kindly have a look.
Lordship had already seen the
Let me
photos
see.
and everything,
All over.
the condition that particular school was in.
My lord, I am referring your
It was,
lordship to last page, my lord. Last page, my lord,
It
of
was in
my
a
affidavit.
dilapidated condition, my lord. Lordship had already made up your.
117, my lord. Lordship will
Now,
kindly have it.
now, suppose you tell me, are you ready to argue the matter?
Lordship, we'll fix it on some other date, man. I'll go through the reply because he has given a reply also to the affidavit which I have given, my lord. Let me go through, my lord, a date may be given, my lord, then we can, my lord, proceed. Sir.
My lord,
Maybe
after filing
after
of,
a week, my lord, maybe after a week.
all of submit. My lord, after filing of this affidavit, my lord, this case has been listed on 2-3 occasions, my lord. Now they are again asking for time, my lord. Everything is clear, my lord. It's a part of record, my lord.
My lord,
Page
an additional
170.
affidavit was filed, my lord.
Just a minute. 117, lordship will kindly have a look, my lord. This is the photograph of the school, my lord. Complete photograph of the school, front side, my lord. And the issue is different, my lord.
When did you file the affidavit in reply?
Affidavit in reply was filed on 16/9/2025, my lord.
In time.
Yes, my lord.
There's only one set, there was only one adjournment.
One, my lord. Exactly, my lord.
That was by them.
My lord, that's what, my lord. And my lord, there was a report also which your lordship last time I had seen it. The lordship has seen the report also, my lord, the condition of the school inside. So the picture which is given here is only of the outside of the school. Here, my lord, the report which has been given, the inside and outside both has been given.
My lord,
The
that,
condition was so bad, my lord. After last time,
my lord,
lordship
that
had-
inquiry was purportedly
had,
shown to be carried out on the day. What?
Lordship, on the last time, Lordship had also had pointed out that is this the condition a school should be run? Lordship had pointed out. Then after that, he had taken adjournment, my lord, and then, my lord, the matter has been fixed after the vacation.
Pune Tamil, one.
Appeal it. Also, appeal can go.
I did not take any attendance.
Some video of it.
My lord, the issue is altogether different, my lord. They said, my lord, in the impugn order that there was no enrollment in the school in the year 2016 and 17, my lord. Whereas, my lord, the inspection report says something else, my lord. If I again, my lord, refer to the inspection report, my lord, it says, my lord, this was never disputed by them, my lord.
Let it be on 23rd in the time, the
Yes,
go
sir.
to the reply.
Well,
My lord.
The pair will set back to the but I- Okay. Let's take the matter on 23rd.
Candidate खुला से ठीक है sir.
Okay. Mr. Jayadavat, Radeko.
Keep it. Well, your lordship wanted to see the latest judgment of the court
Yes.
regarding cancellation of the. Move to go. Their page, paragraph 60. Relevant is paragraph 60 and 61. Lordship has seen the judgment. And there is an appeal preferred by the state also. This was a cancellation of the recruitment process because of the change of the government, madam, basically. And they say some other rule is applicable. So paragraph 60, madam,
Paragraph number 16.
60, paragraph 60, paragraph 60. In my page, paginations are not there. May I read, madam?
Paragraph number 6.
0. Pagination is not there.
Yes.
Malad, from the
Sir,
discussion,
you are for the respondent.
College is also there. The college is also a party. I'll be appearing for higher education process.
Who is attending for the college?
college is there. Ma'am. Is there.
Four and five.
From the discussion made herein above and in the facts of this case, the appellants have participated in the process of recruitment conducted in the furtherance to the provisions of TSR Act and TSR rules. Undisputedly, they found place in the panel of selection. It was only at this stage of character verification the process was kept in abeyance, later cancelled in terms of NRP, which could not have been made applicable to the ongoing recruitment process. The applications of the NRP to the following recruitment process for the post of enroll followers in Tripura State Rifles was not in public interest. Therefore, the appellants do have a legitimate expectation of completion of the recruitment process in a fair and non-arbitrary manner. The recruitment process should be concluded fairly as per TCR Act and TCR rules, and the candidates may be appointed if they are found to be meritorious as such issue number so and so is decided. So paragraph 61, the memorandum cancelling the recruitment process was satisfied. State government also filed an appeal. You also will get it last page, Mala. The state government, Mala, after paragraph 61, your lordship will see the state of Tripura versus so and so regarding boiler. Paragraph 19, Mala. Paragraph 19. Last but 2 page, Mala. Your lordship.
Paragraph number
19.
90.
19.
Yes, it is the contention of the candidate.
No, as such, we are not inclined to. Last page, my lord, last.
Last page of this judgment.
Judgment. No, last page of the bunch, my lord. 2, 3 judgments are there, but I'm citing only one. Last page, my lord. Last but 3 page. Your lordship got it, my lord. As such,
No, after 61, paragraph number 61, another judgment starts.
yes, that is by the state of Tripura. I'm
State of
showing, my
Tripura,
lord,
yeah.
2, 3 judgments are there. I'm showing only the last part, last judgment, paragraph 19. May I just point out this one? Para 19. Only the interview was left to be done after about 6 lines.
Yes,
After about 6 lines, thus only the result of the interview was left to be done, declared. As such, the recruitment process for the post of inspectors of boilers was at a significantly advanced stage when the recruitment process was kept in abeyance, later cancelled by the cancellation memorandum and TPSC notification dated so and so. The applications of the NRP to the ongoing recruitment process was arbitrary and unjust, and candidates do have a legitimate expectation of completions of the recruitment process in a fair and non-arbitrary manner. It is pointed out by the appellant state that in the facts of this case, in the Boilers case Act, central rules or the state rules, or even in the advertisement, there is no prescriptions of marks to be obtained in the written test or the interview. But the fact remains that the written test was already conducted out of 100 marks and the interview was also conducted. As such, the subsequent decision to apply NRP to the state recruitment process cannot be sustained. The recruitment should be completed as per Boiler Act and central rules. So here, my lord, in this case, after the interview, they sought to cancel the recruitment process on the ground, my lord, some other act is applicable. And that also after the change of the government. The court says you cannot do that. In this case, my lord, your lordship will kindly see, interview was already held, your lordship will find from page, your lordship will kindly see page 27. 3 reports I will show, my lord. Which is a report given to the director by the principal of the college. May I just read this? Page 27. In my first paragraph I am giving up, second paragraph, that the state post was vacant on 1/4/19. Since 2019, they have not been able to fill up the post due to retirements of so and as per approved roster register, the roster point is 36, which is reserved for SC. Here the candidate is an SC, my lord. After seeking due permission from the DHE, the college authority first made advertisement in the year 2020, but due to certain reasons, interview was not held. Again, in the year 2022, advertisement was made, the present one, my lord, stating that the candidate who applied against the earlier advertisement did not apply. For second time, altogether 13 numbers of candidates applied. The interview for the said post took place on 19/5/2022, and out of 13 numbers of candidates, 4 candidates had appeared before the selection committee, keeping in view of the screening committee report, and after verifying the academic records and other necessary testimonials, the selection committee duly recorded the marks of each of the candidates in the prescribed format. However, it appears from the records of the prescribed format that 2 applicants, namely so and so, lack proficiency in local language, and Sri Saibal Das did not submit the PRC in proper format. Hence, Uttara Roy, the present petitioner, was the only bona fide candidate fulfilling all the criteria in submitting records and other testimonials.
the whole process of selection was almost completed and recommendations of the name of the selected candidate was to be made. At this stage, it was cancelled to be made. All of a sudden, the process was stopped due to outbreak of flood havoc. Flood was in Kachar Mala, whereas this is in Hailakandi. But anyway, Lord, this is what the things are. The process was stopped due to outbreak of flood havoc. Interview was postponed with a note of the chairman selection committee where it was stated clearly that the interview remained inconclusive and the same interview would be held while normalcy would be restored. That instead of holding the same interview, the GB of the college decided to cancel the interview held on 19/5/22 and resolved to arrange a fresh interview for the post of assistant professor. But this was not held till date. So this is one. And second, your lordship will kindly say, there was a hearing. And the hearing, my lord, they have, there is a speaking order by the director. And it doesn't record why there has been, they have given permission for the people to. Page 54. It starts from page 53. Relevant is that, my lord. Relevant is page 54. I'll not read all the things, my lord. Third paragraph. Page 54. This is hearing taken by the Director Higher Education at the instance of the petitioner's application. This is the last paragraph, my lord. Third paragraph. That while the process of selection was almost completed and recommendations of the name of the selected candidate was to be made, all of a sudden the process was stopped due to outbreak of hard havoc interview as postponed with a notice of the chairman of the selection committee where it was stated clearly that the interview remained inconclusive and the same interview would be held while normalcy would be restored. That instead of holding the same interview, the governing body of the college decided to cancel the interview held on so and so and resolved to arrange a fresh interview for the post of assistant professor so and so. That last paragraph. On scrutiny of the above report received from the principal and in pursuance to the resolutions dated 7/6/22 adopted by the governing body of the SSF College, Hailakandi, it is decided to request the principal of the college to take necessary initiative to go for a fresh applicant. There is no reason. Almost one of these two reports which I have shown, my lord, it shows that the interview was completed. Results are to be declared formally. Even the candidates have been also selected. At that stage, my lord, they sought to cancel it. My lord, last report, your lordship will kindly see page 96. This is the last letter written by the principal on 24/3/25. Your lordship may note, this is a report given to the principal, to the director higher. Number 1, 2, 3, I'm not reading it because it's not necessary. But 3, last part. The 3 last part, the interview was successfully conducted on 19/5/22 by the duly constituted selection committee. Number 4, last part. Individual marking statements prepared and signed by the members of the selection committee. And what is left to be done? Nothing is left to be done. What is the reason for re-advertisement? So I'm just showing one paragraph, my lord, in respect of page 97, in respect of botany, my lord, where one candidate appeared, they have finalized it. Page 97 and 98. It's not, may not be relevant for this, but I'm just showing where one candidate appeared and they have selected the candidate. Page 97, 98. Here out of 13, 14, 4 appeared. And they have completed the selection process. But without assigning any reason, there is no good reason for cancellation. They have just cancelled it and they have, now they have issued a fresh apply. Under facts and circumstances, my lord, I have provided your lordship two judgments also, besides the judgment which may not be relevant. Unless a reasonable ground is there, you cannot interfere with the process of selection. And that I have given it earlier. Cannot cancel arbitrarily. 2010 7 SCC 678. Paragraph 10 will do, my lord. Written test for chief typist. Paragraph 7 and 8, my lord, High Court found fault with the order of cancellation as no reason.
Paragraph numbers?
Paragraph 2, 3, and 4, your lordship will find that written test was held for chief typist. Paragraph 16 is relevant. Applying this principle to the case at hand, there is no gainsaying that while the candidates who appeared in the typewriting test had no indefeasible or absolute right to seek appointment, yet the same did not give a license to the competent authority to cancel the examination and the result thereof in an arbitrary manner. The list which the candidates who were otherwise eligible for appointment and who had appeared in the examination that constitute a step in aid of a possible appointment in their favor were entitled to is to ensure that the selection process was not allowed to be scuttled for malafide reasons or in an arbitrary manner. So here also, my lord, the present case, my lord, without any reasons, my lord, after completing the whole process, only the results, even the candidates have been selected, only the results are to be declared. Chairman said, no, we'll complete the first, he said, we'll complete the process. That means the only thing is left is that to forward the name of the selected person. At that stage, my lord, they say, no, we will go for cancellation only. So whether it is reasonable, whether it is arbitrary, and whether it can be sustained. And another judgment is there, my lord, I am not pressing for the time being. But there also it says same, arbitrarily you cannot do. Deeply.
Yes.
So if records are as directed by DCL, records are with you.
Pardon?
Records are with you. So for, there is a direction to produce all that.
Produce the
At the very outset, kindly peruse the page number 65 of my affidavit of proof. Page number 65.
next one.
Next one. Everything started from there. In pursuance of the letter of the Deputy Commissioner, some chairperson, disaster management authority, Kachati. And so far as the college is concerned, is in Hailakandi district, not in Kachati. It refers for Kachar district, not for Hailakandi district. By number 7 dated 18/5/2022, the university and its affiliated colleges across all the districts, not in Hailakandi district, and so far as the present college is concerned, is affiliated to Assam University. It falls within the jurisdiction of Assam University. Though it doesn't fall in Kachar district, it falls in Hailakandi district, but it belongs to, it is affiliated to Assam University. So it refers to within the jurisdiction of Assam University shall remain closed till 25/2022. Interview was supposed to held on 19/5.
This is further inform all concerned that the program of the university and other Shahid Diwas so and so. So other program will be now connected to page number 66. The process of interview for selection of assistant professor of political science roster point number 7 so remain inconclusive owing to sudden flood havoc in the adjoining areas of Hailakandi and in suspension of all activities under Assam University's research jurisdiction by letter number 7. So why it has been postponed, Your Lordship? Because there was flood havoc in and around Hailakandi district as well, Your Lordship, and also because of the suspension of activities pursuant to the letter dated 18/5/2022. All the members of the selection committee had to leave the college instantly owing to reported disruption of road communication. It is decided to hold the same interview after the restoration of normalcy, observing all necessary formalities at a convenient time.
No, there the interview was held.
No, Lordship, it is issued on 19/5/20 on the day of interview.
No, there, sir.
Hereafter, no interview was held.
Interview was held.
Hereafter, no interview was held. On
My lord,
19/5/2000
on 19th itself, they have completed the process.
on 19th,
The two
Statement of-
reports which I have shown, my lord, which I have read, my lord, 19th itself, everything is completed, only that they are to selection list, declaration has to be left, has been left to be done. 19th itself they have completed, all interviews they completed in one day.
interview was on 19/5/2022 itself.
And it says, my lord,
Second para,
It-
all the members of selection committee had to leave the college instantly owing to reported
decided to hold the
disruption.
same interview after that.
19/5 itself, Your Lordship, this is finished. Now, Your Lordship, annexed see page number 67. After a third-year discussion, DB so and so, a fresh interview be held for the post of so and so. So they are agreed by this, Your Lordship. Please understand. Said interview will remain into owing to the sudden supervision of all activities under Assam Sector so and flood havoc adjoining localities of Hailakandi town. So same repetition, Your Lordship. Now, after that, Your Lordship, the petitioner preferred a representation before the Director Higher Education on 13/3/2024. It is on Annex 4, Your Lordship. Lordship, second para. Annex 4, page number 68. Second para. This is a representation filed by the petitioner. Sir, surprisingly, on 7 June, so and so, the SS College governing body had cited a notice which was issued by so and so sector on so and so based on a reference letter dated so and so had cancelled the completed interview. The letter of District Disaster Management Authority Kachar had clearly mentioned only Kachar district and nowhere written about cancellation of interview of the district like Hailakandi. So, see, as I have pointed out in Annex 1, page number 65, there is a clear direction by the Registrar of Assam University that the university and its affiliated colleges across all the districts. Now, next paragraph, okay? Sir, it is also mentioned that DC cum chairman, District Disaster Management Authority Hailakandi, had issued a circular, so and so. So it refers to the district where the college is situated. It is regarding the Hailakandi district. To ensure the connectivity of the people. And nowhere mention about suspension of the activities in Hailakandi district and cancellation of any interview. Lordship, I have obtained that letter. This is with me, Your Lordship. That letter also refers there is a havoc because of flood, Your Lordship, and so far as other districts, how they will enter into the district of Hailakandi, Your Lordship, that has been bifurcated, and on that day itself, Your Lordship, situation was so havoc. Even the interviewer had to left. I will produce this letter that has been referred by the petitioner herself, and I am producing that letter. where Lordship can infer the situation that was prevailing on that date, that is on 19/5/2022 year, that's for the day of death. From where the interviewers who are all are from Qatar and Koringal district, except the HOD and the principal of the concerned district, that is Hailagan. Rest of the interviewers from not from Hailagan district.
So according to you, on 19/5/2022, no interview was held.
Held. Even statement was in marks were also being recorded in the statement of record. I have produced the record here. Lordship.
Okay, there,
Thereafter, what is to be done is Lordship, they have to recommend and that is to be sent to the governing body.
Yeah.
And governing body, after taking that we had discussion and all, they have to recommend and send it to the director for approval. And thereafter, the principal will issue the appointment will be done. This is the process, Your Lordship. So far as director is concerned, there is not much need to, not required to do much here. Only thing is to be done by the governing body. After reference, forwarding of the selection committee, Your Lordship, they have to send the selection committee recommendation to the governing body. Your Lordship. Here, there are no recommendation. Only marks are recorded in the statement, Your Lordship. Rest of the process, so far as the selection body is concerned, we are in the year 2022 years. That was not completed. Now it is 2025 years.
why the selection process was cancelled then?
Cancellation was because, Your Lordship, first it was postponed, thereafter it was cancelled because, Your Lordship, much time has been left, Your Lordship. The interviewers, those who are in the selection committee, whether they are alive or not at this point, I have no instruction yet regard. Whether we can, at this stage, Your Lordship, we can invite them, we can get them again to conclude that selection at this stage, Your Lordship, because we have to constitute again, Your Lordship, that selection committee. The members, whether they are available or not, that is one perspective.
It is the ground.
Lordship, I am not saying that it is a ground, Your Lordship,
Yeah.
and only thing is that, Your Lordship, they have appeared.
No,
Phone number.
if you are admitting that the interview was held on 19/5/2022.
But it was not completed because of the sudden havoc of the flood, Your Lordship. It is on record, Your Lordship.
Then, there, sir, why you could not complete the process?
Lordship, resolution that is under challenge, Your Lordship. Lordship, may kindly page number, connector is page number 80. It is on 23/2024, Your Lordship.
Yes.
And there are page number 82, Your Lordship. Resolution number 14. By that time, Your Lordship, that was cancelled by the director and it was directed to take fresh advertisement, Your Lordship, to go for fresh advertisement as issued by the director. And that is under challenge. Connector 7, page number 79. Reference petition dated transfer. It was heard and accordingly. So proper Malafide part is concerned, and the only thing is that is there any Malafide or not on our part yet? There is no Malafide, there is no arbitrariness, because in other words, they have no indefeasible rights.
No, first you have to satisfy that the ground for cancellation is not arbitrary.
So it was said there was large havoc here, let's say, was changed, and I have also put in the
No,
letter.
that was in the month of May.
Like on the day of interview, let's say, on 19/5,
That's
2022.
all right. On 19/5, 2022, there was flood.
Yes, sir, on the,
Then the flood continued for whole the year.
no, no.
Then
Then subsequently it should have been completed.
why it could not be
But-
completed?
Thereafter it has been cancelled, your lordship.
Why?
They have filed, it is the petitioner who has filed a representation before the director, your lordship. After hearing that, your lordship, director has filed an order directing to cancel and go for fresh advertisement.
What is the explanation given by the director? What is the reason given by the director for cancellation?
Note that. Page number 77, your lordship. Further, the governing body of the college has adopted resolution number 5B dated so 7/6/22 that a fresh interview to be held for the post of so, cancelling the new interview held on so.
So the director
We are on the- we are
relies
on-
upon the resolution of the governing body.
Yes, sir, we are for the
What
fresh
is the
interview.
reason assigned by the governing body?
We are on the fresh interview, not for fresh advertisement at that point of time, yes, sir. Now, what else the interview held on also remain inconclusive, owing to the sudden suspension of all activities under so letter dated so. On scrutiny, the above report received from so principal dated so adopted by the governing body, it is decided to request principal Professor Hailagandi to take necessary initiative to take a fresh advertisement interview to the post of. Our resolution was to take fresh interviews, not for fresh advertisement at that point of time. But after hearing your lordship, director has given the rider that conduct a fresh interview. And thereafter your lordship, the impugn letter dated
So let us see the resolution of the governing body.
resolution is at
Page number.
resolution is at page number 67, your lordship. Yes, sir. 87 of the activity. Not petition of open access, sir. Okay. You can expect it.
So, Mr. Kothuri, you see, 19/5/2022 on which the interview was held.
Yes.
And this resolution was adopted by the governing body after more than 2 years,
Yes, sir. By that time,
9/8/2024.
yes, sir.
But
By-
what happened in the meantime? Why you could not convene the meeting of the selection board,
Sir, kindly see
selection committee?
annexure 2, page number 66.
Page number?
66. It is on 19/5/22 itself, sir. The process,
days, man.
process, no,
They
it's
have
not,
cancelled after 7 days. It was 22, my lord. 22, my lord, the resolution was passed for
Sir, kindly see annexure 2,
18/7/22.
annexure 2, page number 66.
Yes.
It was on the day of interview, 19/5/2022. That has been issued by the president governing body. The process of interview for selection of assistant professor of political science so remain inconclusive owing to the certain flood havoc in the adjoining areas of Hailagandi and the suspension of all the activities under Assam University sector. And this SS college is affiliated to Assam University. Annexure 1 that has been specifically stated, your lordship, within the jurisdiction of Assam University shall remain closed till 25/7/22. And I have also produced a letter, your lordship, the situation lordship may infer on that day what had happened, your lordship. And it is on annexure 2, page number 6, second para.
No, you see, okay, the resolution was signed on 9/8/2024, but it was adopted on 7/6/2020.
Okay.
Annexure 3.
Yes.
There's a resolution of the ZB is of dated 7/6/2022.
Yes, sir. Yes, sir. So signed 9/8/24. This is an extracted copy. Original I have produced. This is an extract copy of the resolution. That has been extracted and it has been forwarded by friends of 9/8/2024. This is an extract copy of the resolution dated 7/6/2022. Extracted copy. Resolution is in the resolution book, your lordship.
So, why the remaining part of the process could not be completed then?
Lordship, thereafter, annexure 4. In the meantime, petitioner preferred a representation before the director on 13/3/2023.
No,
Where-
that is not after the resolution of this ZB dated 7/6/2022.
Yes, lordship.
Annexure 4 was filed on 13/3/2020.
Yes, lordship.
23.
Yes, lordship. By the time we are supposed to take your press interview, your lordship, but all the interviewer at this stage, your lordship, by that time, probably I have no instruction in that regard, your lordship, but
No, you were supposed to argue the matter with all your instructions.
at this stage, your lordship, at this stage, 2025, your lordship. Now, whether all the interviewers, those who are in the selection committee, whether they are available or not at this now, your lordship, it is to be considered.
Yes, Mr. Does anything to submit?
Nothing, my lord, only, no, they, on the, oh,
Yes.
The decision taken by the director was
On the
But,
basis of the resolution of the ZB.
regulation of the city and considering the larger interest of the candidate applied for the post, my lord, because
That's all right, but if the ZB press for allowing it to hold a press interview,
yes, sir.
then you have cancelled it.
So cancel, my lord, after after a lot of time, my lord, because initially the resolution was taken for press interview, my lord.
Hmm.
Then the petitioner filed representation, hearing was taken place. Then by the time, my lord, lot of time has been
No, the petitioner has filed representation for completion of the process.
Yes,
He
sir.
has not prayed for cancellation of the interview.
No, no, no. Yes, no. The completion of the petition of prayed for completion of the earlier process, my lord. But by the time, my lord, the hearing was taken place with the principal of the college and petitioner. Thereafter, report was called for from the my lord, college authority. By the time, a lot of time has been elapsed, my lord, and considering the all facts, my lord, the director decided to go for a fresh advertise.
And whether any reason is assigned by the director while cancelling the interview?
Documents doesn't say
Then from where we will infer the reason?
I have spoken to the authorities, whether what was the ground, Then it was while discussing, it was said that considering the all facts and considering the larger interest of the candidates, matlab, at that
What
It
is
was
the
the
larger
decision was
interest of the candidate?
because although 13 candidates has applied for the post, my lord, they could not come due to floods. And by the time, my lord, almost 1 year, I think, almost 1 year, my lord, has elapsed by the time the decision was to be taken. But by that time, more candidates is, got eligibility to apply for the post.
So that is the ground for cancellation.
Yes, my lord.
Yes, any reply?
My lord, your lordship has seen on the face of the record, my lord, all the process has been completed and the results are to be declared at this stage, my lord, the decision has been taken for re-advertisement. That is no reason for cancellation of the cancellation of the, my lord, interview process which was concluded. And the reason for cancellation, my lord, your lordship will get it from their own record. They cannot add by orally submitting something which is not there. For that, my lord, I will rely on one judgment,
No,
1978.
that is well settled proposition of law. They cannot supplement.
They cannot supplement. So something else is written on learned counsel is say some other reason on the basis of the discussion. They cannot do that, my lord.
They
This is
cannot,
not
yes.
the process of law. So therefore, my only submission for the court is that the three reports which I have submitted as shown before your lordship, that is at page 27, page 27, if I may take your lordship once again, that it shows very clearly, it starts from page 27, it's a report from the principal of the college. And well, last paragraph of paragraph 27, it says the interview for the post took place on 19/5/22 and out of 13, 4 appeared before the selection committee, keeping in view of the scrutiny committee report and after verifying the academic records and other necessary testimonials, the selection committee duly recorded the marks of each of the candidates prescribed format. However, it appears from the so-and-so, the petitioner has been found to be the selected candidates. That while the process of selection was almost completed, and recommendations of the name of the selected candidate was to be made, all of a sudden the process was stopped due to outbreak of flood. If there is any stoppage due to outbreak of the flood, next day the school was open, the colleges were open. They could have done it. Instead of that, they have just cancelled it after 6 days. That is not the reason, mother. This is arbitrary and this is an harassment cost to the petition. Since 2019, they are unable to fill up the post because it belongs to a scheduled caste candidate. And the same report which I have shown, my lord, before your lordship, that page 96 also shows the same. Page 96, the report submitted by the principal that marks completed, marks have been awarded already. And individual marking statements prepared and signed by the members of the selection committee. That page 96. Page 96, my lord, serial number 3, last, my lord. Last, the interview was successfully conducted on 19/5/22 by the duly constituted selection committee. This part your lordship will record. And number 4, last part,
You were referring to page number
96,
96. That is annexure 17.
17 months.
Okay.
The letter written from the principal of the college to the director of higher education on 24/3/25.
Yes.
So serial number 3, I'm not ever going through all the documents. My lord.
Okay.
Serial number 3, last part, dot. The interview was successfully conducted on 19/5/22 by the duly constituted selection committee. Has your lordship got it? They themselves says, my lord, interview was completed successfully. Has your lordship got it? Yes. Now, number 4, last part. Individual marking statements prepared and signed by the members of the selection committee. What is left, my lord? Only to declare the results. for that purpose, my lord, they will cancel it. The legislation expectation part which have shown that Supreme Court judgment, it is there with her. You select the candidate, then thereafter, my lord, maybe they don't like their case. They say, no, we'll go for fresh interview. So on the face of it, my lord, I submit, my lord, this is without any reason, it is arbitrary, and therefore it is liable to be set aside, and they are to declare the results of the candidates as has been already stated by them.
Okay.
Deeply obliged.
So, okay, so Tony, is it not your letter? Page number 96 and answer 70?
Yes.
So here it is stated that the individual marks have been given by the members of the selection committee.
Individual marks that has been in the statement, Your Lordship. Thereafter, selection committee is required to,
And signed by the members of the selection committee.
thereafter other duties left, Your Lordship, for the selection committee. They have to recommend, Your Lordship. Then it is to be sent to the governing body. Once governing body get it, Your
So
Lordship,
thereafter, why the process could not be carried forward? Could not be carried.
initially it was postponed. Thereafter, it has been decided as adopting a resolution to take fresh interview. That is under challenge, Your Lordship. And actually,
So is it your case that on 19/5/2022, some of the candidates could not appear on account of this flood havoc?
4 appeared out of 13. Your Lordship. Altogether, there are 13 candidates. 4 appeared in the interview. But
But whether you have reflected this aspect in your letter or in the resolution of the ZB?
in the letter, it has been reflected that out of 13, 4 appeared with.
In this regard, I'll just point out one thing, my lord. Paragraph 12, we have stated the post for political science was 2. One was reserved, one was unreserved. For unreserved candidate also, 23 applied, only 4 appeared. Out of that, four selection was done. And again, in respect of the botany, I've shown 1 post, 4 appeared, 1 was selected. But that is not, this is not the reason.
Oh, we'll pass the order.
Yes. Deeply obliged.
Okay, record read.
Record will be here till pronouncement of the judge.
Well, the future loss is irrelevant because none of my juniors could reach because of the heavy traffic. Item number 5 has been passed over for non-appears. For
Yes.
either let me take it up on the reopening or
Okay. After a week, we
date may
can
be
fix
fixed.
a date, of course.
Sorry.
We can fix a date.
Yes, a date may be fixed so that because there is urgency in the matter. But then unfortunately today, we could not reach the time. That is the difficult. 23rd, my lord.
Give up the matter. Huh?
Or if possible, today itself has last item.
The time may not permit,
That's why I have to, because if board,
uh,
how much it is there?
Last week of October.
23rd Friday? Thursday. Huh? Thursday. Hearing there, the
28, Tuesday, 28.
hearing day? 28. Oblige. Oh dear.
Timing items 6 and 7.
Well, so far item number 6 is concerned, well, again, the petitioner and inquiry was initiated. At page 30, your lordship may see in Malo,
who is for the respondents?
the phone is there, man, he's coming. Coming. He is there. He is there. Page 30. Joint Secretary to Governor Assam, my lord. He initiated an inquiry. By this, my lord, I will ask to submit stopwatch and have submitted the stopwatch. And thereafter, my lord, inquiry officer was appointed and inquiry officer inquired the matter and submitted a report. Page 43, your lordship may see, my lord. Page 43 is the report. The last para, page 43, findings. Your lordship, my lord,
It's 43.
43.
It is part of annexure P 5P.
Yes, yes, yes. Part of annexure 9. WBC, my lord, 22, my lord, 7743, 22. That's the first case, my lord. Oh, then I have to, my lord, again refer to my lord, page 30, your office, my lord, that inquiry was started, annexure 3.
Yes.
This is the inquiry, my lord, initiation. Then we submitted stopwatch, then inquiry officer appointed. The inquiry has submitted the report, page 42. Your office. He is the additional secretary to Governor of Assam and inquiry officer, my lord. The secretary. With reference to above, I have honor to submit herewith the inquiry report on the DP along with the recorded statement of so-and-so in favor of the state. And next page, you will also find page 43, my lord. Last para, my lord, you will also see findings. From the paper submitted by the department, the written statement of the charge officer or the recorded statement of the charge officer, no material facts could be derived to prove that the charge officer has misused his official position or he has violated rule 3 of the conduct rules. As the charge is entirely based on police action and in absence of any final report of the police, the charges leveled against the charge officer is not proved. So, my lord, charge is not proved, my lord. So, police investigation is going on, my lord. Now, the impugned order is, my lord, at page 49.
So in DP, he was exonerated.
Yeah, but, no, my lord, this inquiry officer submitted a report that did not pass any consequential order.
Okay.
Now, my lord, again, my lord, the second inquiry has been initiated, my lord. Page 49.
The same charge?
My lord, yeah, same charge. Same charge. I'm just placing, my lord, page 49.
Yes.
Whereas an inquiry under Rule 9 of the Assam Services Disciplinary Appeal was held in respect of charge framed by Sri Bambu Singh, so and so, so and so, so and so. And whereas the Binavu Singh was furnished a reply, so and so, so and so. where department posting could not be completed. My lord, this is wrong, my lord. They have not considered it. Department could not be completed due to lack of sufficient documentary evidence or presence of statement of police as witness, in absence of which it is difficult to prove the allegation. But it is absolutely perverse, my lord, that the department posting could not be completed. This is wrong, my lord. Now, whereas the governor of Assam decided to carry out further inquiry on the basis of the final investigation report received from the superintendent of police, vigilance and anti-corruption, Assam, in order to dispose of the demand proceeding against the so-and-so. Now, therefore, Governor Assam in exercise of power so-and-so, please to appoint series so-and-so, again, under the appointed. So this was challenged before this honorable court, my lord, and this honorable court stated the same. If you also see that order that 5/12/22, my lord, the first order, the paragraph 7.
Order was passed in the other.
No, no, in this case, my lord, the first order was passed, my lord, staying this, second inquiry. First, 5/12/22.
Wait,
The first order of this honorable court.
no, in this case, there is no order set.
My lord,
In this case, there is no.
the interim order was there, my lord. First order. First order. Five 12/22. I have annexed the order in the second case also. You also may see it from there also. Well, in this order, my lord, paragraph 6 may be seen, my lord, that please the consideration of this honorable court while passing the interim order, my lord. This was in 22, my lord. Paragraph 7. On considering the provisions of Rule 9 of Assam Services Disciplinary Appeal Rules 1964, read conjointly with para 6.1.8.1 and 6.8.12 of Chapter 4 of the Manual of Development Proceedings, it primarily appears from the interim order that the competent authority had not taken into consideration the report dated 9/1/20, my lord, this is, of the inquiry officer, and the said order does not disclose the decision, if any, taken by the decision authority of rejecting the inquiry report. That inquiry report has not been rejected, my lord. The interim order also does not disclose as to whether the petitioner was given a genuine opportunity of being heard in terms of para 6.1.8.2 of the Manual of Development Proceedings before a press inquiry. Moreover, the interim order does not disclose as to whether earlier inquiry report has been rejected. Well, this is the main, my case is this, my lord. My case is this, if you will also see the, my lord, the Manual of Department Proceeding, my lord, please, para 6.1.8. My lord, page 379, my lord. You also got.
You are referring to Assam Service Discipline and Appeal Rule 1964.
Manual of Department Proceeding, my lord, mainly the page, Manual of Department Proceeding, my lord, starts at, my lord, at page 327. And I am referring to page 379. Yes, your loss is met. Your loss is met. Nine. 6.1.8 and 6.1.8.1 2.
You were referring to 6.18. Oh,
18.1 and 18.2. That was my lord, the order my lord, referred to. My lord, because they have to give an opportunity to me, my lord. If such things is there. They have not rejected that inquiry report. Inquiry report has been submitted. If they reject the inquiry report, my lord, they have to give an opportunity to me, my lord. Okay.
okay. So your contention is that no decision is taken on the earlier
Yes, my lord.
inquiry proceeding.
No, that final, my lord, that report has been submitted. No, the allegation are not proved, my lord, and they have to first take a decision, and they have to give a notice to me also, my lord.
Only thereafter they can
Thereafter, they can.
proceed to a
Yes.
second.
Yes.
department.
Yes. This is my case.
Yes, therefore.
Lordship may kindly
I can refer to one judgment also, my lord. Your lordship just may. I refer to this for my man. Paragraph 5 and 8, my lord. Just your lord. I've heard the land counsel for the parties and perused the records. From the perusal of the records, it appears that earlier department inquiry was held against the petitioner. In the said inquiry officer does not found the charges as proved against the petitioner, and therefore a re-inquiry was decided to be held against the petitioner. However, before holding the re-inquiry, no so-called notice was issued to the petitioner. This court in so and so has held. This said the reply of the charges sheet submitted by petitioner. This inquiry was conducted against him for the aforesaid charges of misconduct. The inquiry officer conclusion of the inquiry submitted inquiry report before a district authority. In the inquiry officer did not find any petitioner guilty of both the charges held against the petitioner charges not proved. District authority, after going through the inquiry report, submitted the inquiry officer, disagreeing with the finding of the inquiry report on both the charges, recorded the finding of the guilt of the petitioner in regard to both the charges and imposed penalty of deduction of pay for interest. No pay right. Pay right, my lord. In the present case, also the first inquiry charges are not proved, not found to be proved against the petitioner. Therefore, in the light of the judgment passed by the West Court, second inquiry on the same set of charges is not permissible, In the present case, there is no financial loss that is exposed to the bank, and therefore financial imposed on the petitioner too harsh and disproportionate in view of the aforesaid discussion of the petitioner.
Okay.
Hmm.
Yes, the point.
Well, please.
So today, page number 30 of this writ petition, your annexure 3.
Oh, we're gonna do after 5.
Yes.
Yes, Mr. Kumar.
Yes. Sir. Actually, may kindly go to the page number 30, annexure 3 of his writ petition. So good. First one.
Page number 33.
30, 30, annexure 3.
Yeah.
This is the so called zero. You are hereby required to show cause under Rule 9 of the Assam Services Discipline and Appeal Rules 1954, reduced Article 311 of the Constitution of India, why any of the penalties prescribed in Rule 7 of the aforesaid rules should not be inflicted on you on the following charges based on the statement of allegation attached herewith. That while you were holding the post of Assistant Planning Officer in the office of the Deputy Commissioner Dorong, you were arrested on 12/8/2016 in reference to ACB PS case number such and such under such and such section. Prevention of Corruption Act is also there. Also provision for involvement in accepting bribe of rupees 15,000. You are therefore not only charged with misuse of official position, but also thereby violation of Rule 3, Roman 3 of the Assam Civil Services Conduct Rules 1965 and gross indiscipline. You should submit your written statement in defense within 10 days. Your Lordship, a criminal case was registered against him because it was a theft case, Your Lordship, while he was receiving the bribe money, then he along with other persons were caught red-handed by the police officer. This is the charge. And subsequent page is a written statement. May I read, Your Lordship?
Page number?
Page number 31, annexure 4. This so cause reply. I am in receipt of your above noted so cause notice dated so and so, issued under Rule 9 of the Assam Discipline and Appeal Rule, read with Article 311 of the Constitution of India and take me state as an. Yes, sir. It is seen that so cause notice has been issued consequent to my arrest on 12/8/2016 in connection with ACB PS case number such and such.
Mr. Kumar, you
Yes.
see. So, based off of this, supposed reply.
Yes.
The departmental proceeding was initiated against him.
Yes. Yes.
Then it has also been concluded, but no order has been passed. Then without passing any order, again, fresh departmental proceeding has been initiated against him.
Your Lordship, this is not the de novo inquiry or first inquiry, it is further inquiry. And
Further
it is-
inquiry.
Yes, and the law is well settled. It is
Further
settled law.
inquiry.
Further inquiry can be held.
But without passing any order about the earlier inquiry.
Your Lordship, in the impugn order itself, it is observed.
Let us see. Annexure 11 is the impugn order.
Yes. Yes. Your Lordship, paragraph 3 of this page number 49, the inquiry order. whereas the departmental proceeding could not be completed due to lack of sufficient documentary evidence and presence of the statement of police as witnessed, in the absence of which it was difficult to prove the allegation. Your Lordship, the inquiry officer was appointed, and inquiry officer, after making some inquiry, because at the time of his inquiry, Your Lordship, the witnesses and documentary evidence were not available because it entirely based on the police case, Your Lordship. So it could not be concluded, Your Lordship. It could not be completed. Only he submitted a report saying since the it based on the police reports, so those are not available, so it could not be proved. And it is settled law. If the at the time of inquiry, first inquiry, Your Lordship, the time of inquiry, if the authority finds that at the time of inquiry, evidence and documents were not available for certain reasons, then authority, the disciplinary authority can pass its own order considering the available materials, or the authority, disciplinary authority may remit back to the matter to the inquiry officer for further inquiry, if subsequently it is available.
No, whether any such order was passed by the disciplinary authority.
Yes, Your Lordship.
Whether any such order was passed by the disciplinary authority. For further inquiry.
Yes, Your Lordship.
Page number?
Your Lordship, the impugn order, page number 11. Page number 11.
11. Annexure 11,
Annexa 11, page number 49.
49.
Yes.
So
Now,
you
therefore,
tell
the
me
governor of
where it is stated that it is further inquiry.
Your Lordship, kindly see the next paragraph. The paragraph number 1, 2, 3, 4, Your Lordship. Whereas the governor of Assam has decided to carry out further inquiry on the basis of final investigation report received from the superintendent of police, such and such, in order to dispose of the departmental proceeding against Mr. So-and-so. Because those documents and evidence become available to the authority while the investigating agency submitted entire record before it's seeking the prosecution sanction. Then only it is considered. Came to the into the hands of the disciplinary authority. Then ultimately it is decided. Lordship, kindly see my affidavit.
Page number?
Your Lordship, page number 71 of my affidavit.
71.
71.
Yes.
Second paragraph, it is pertinent to mention. It is pertinent to mention here that the charges against the petitioner were entirely based on the police action and in the absence of sufficient documentary evidence, as well as lack of witnesses in support of the charges framed against the petitioner. These disciplinary proceedings could not be disposed of. In order to resolve the aforesaid deadlock, the additional secretary to the Government of Assam Transformation and Development Department addressed a letter dated 15/6/2020 to the Superintendent of Police, Vigilance and Anti-Corruption Assam, requesting him to furnish the present status of the case number so-and-so against the petition. In response to the Superintendent Police No, responding, the police, superintendent of police, each letter dated such and such addressed to the additional secretary. Such and such department stated the circumstances under which the petitioner was arrested and sent to judicial custody for accepting bribe. The prevention of corruption and pending for further investigation. Thereafter, the additional secretary to the Government of Assam Transformation and Development Department once again addressed a letter dated 17/12/2020 to the Superintendent of Police requesting him to submit the final report after carrying out the investigation of the case being ACB case number such and such against the petitioner at the earliest. Finally, the Superintendent of Police by its letter dated 19/5/2022 provided the additional Chief Secretary Transformation and Development Department with a detailed investigation report containing details about the investigation carried out along with copies of the relevant documents of the case, like FIR copy, statement of the complainant, statement of accused person, statement of witnesses, Caesar list, FSL report, etc. For the perusal of competent authority and further requested the additional Chief Secretary Transformation and Development Department accord sanction under Section 19 of the Prevention of Corruption Act to prosecute the petitioner. After careful examination of the materials and the documents by the Superintendent of Police, Directorate of Vigilance and Anti-Corruption Assam, and after being fully satisfied that the materials on record established such and such, so after approval was given for prosecution. After receiving an approval from the Honorable Chief Minister of Assam, by his order bearing order number such and such dated 3/8/2022, it is pertinent to mention here that by the aforesaid order dated 3/8/2022, Transformation and Development Department was further directed to carry out further inquiry from the stage where the disciplinary proceeding was last carried out. So in such circumstances, Your Lordship, further inquiry was initiated. And it is settled law, Your Lordship, further inquiry can be held. And one ground raised by my learned senior, Your Lordship, senior friend, Your Lordship, that before initiation of this further inquiry, he's saying it, he's harping that he's stating that it is a de novo inquiry. Your Lordship, while the decision was taken, then Your Lordship, a letter was issued to the petitioner, present petitioner, at page number 107 of my affidavit, the Annexer R. It was basically that no notice was given to him. I am that it is issued by the Joint Secretary to the petitioner. In inviting a reference to the letter cited above, I am directed to request you to give writing whether you would like to inspect any document contained in the department file in person or would want any copy of such documents before holding of the inquiry in connection with departmental proceeding initiated against you. Further, you are requested to intimate whether you desire to be heard yourself or would take the assistance of any government servant other than any legal practitioner with the approval of the disciplinary authority. Your reply in this regard should be submitted within 3 days of receipt of this letter. Then, Your Lordship, after receiving that letter, the petitioner submitted a reply. Next page, 108 page number. Annexer S. With reference to subject cited above, I have the honor to state that I have been served with the order dated 16/8/2022, which indicates that departmental authorities have taken a decision to reinitiate the departmental proceeding on the same issue and subject, and accordingly, your honor has served upon me the above letter dated so and so. I have received the same and had gone to the contents thereof. In this regard, I'd like to pray before your good self to allow me to inspect the file of the departmental proceeding and be further pleased to provide me the photocopies of the entire materials on record of the above concerned file. Apart from that, I would like to present my case myself during the course of hearing. So, as per this reply, he was willing to participate in the further inquiry.
Okay.
Your lordship, so far from the record, it appears that it is a further inquiry. It is not de novo inquiry. And what the Honorable Supreme Court said. 1999 5 SCC page 762. Your lordship, I'd like to rely upon paragraph number 10, 10 and 11. 95 1999 5 SCC 762. In a similar situation, the 10, paragraph 10, the law is well settled. The disciplinary authority on receiving the report of the inquiry officer may or may not agree with the findings recorded by the latter. In case of disagreement, the disciplinary authority has to record the reasons for disagreement and then to record his own finding if the evidence available on record is sufficient for such exercise.
Mr. Kumar, this judgment will not help you. Because here, in this case, the report of the inquiry officer was not placed before the disciplinary authority. And disciplinary authority has to record his disagreement with the finding of the inquiry officer. Only in that case, the disagreement note has to be prepared and a copy of the same has to be furnished.
Your lordship, the disagreement.
No, you to tell me whether the matter was inquiry report was placed before the disciplinary authority or not.
Yes, your lordship.
Placed before the disciplinary authority.
Yes, sir.
Then where is the report of the finding of the disciplinary authority?
It is itself reflected in the Annexure 11.
No, Annexure 11 will not do. That is the order passed by the Chief Secretary.
Additional Chief Secretary.
Yes.
Yes, he is the disciplinary authority.
He is the disciplinary authority.
Yes.
Better, Mr. Kumar, you produce the relevant file before this court.
Yes.
We will.
Yes.
Mr. Sayola,
My lord.
let him produce the file.
Yes, my lord, but only thing, my lord, I'm one against, I mean, my lord, say 11. My lord, the finding is absolutely perverse. It says, if your lordship see Annex 11, where third para, where department posting could not be completed. This is not correct, my lord. First thing, department posting, my lord, virtually the inquiry report is complete. Now he has to disagree with the inquiry report on the basis, some basis, my lord. And then he has to give me a notice, my lord.
Yes.
Notice.
The disagreement note
Yes.
has to be prepared.
Yes,
And copy of the same has to be furnished to the
yes,
delinquent officer.
my lord. That is my case is only this, my lord.
Now the question is whether it was placed before the disciplinary authority or not. That has to be ascertained from the file, concerned file. Let him produce the file.
Yes, sir.
We will keep the matter as parted.
Yes, my lord.
Heard Mr. Ian Sayola, learned counsel assisted by Mr. Professor, learned counsel for the more for learned additional senior government
Easy, your additional easy.
additional AG.
Yes.
Okay. Additional AG for the state respondent. Heard in part,
Yes.
place the matter on. Okay. 1 10 maybe. 1 minute. On that day, Mr. Kumar learned.
My lord,
It
it may not be 30 and maybe 15, my lord. It may be on 15.
15.
13, I shall not.
What is the relevant file
Huh?
before this court?
Oh, sorry. Oh, I'm sorry. All right. 30. So both matters will come together. my lord.
Yes, yes.
That's it, I have received the instruction.
Yes.
Like it, today we have received the instruction. So I'll consider it and it takes time.
Your lordship, if additional time is awarded, it will just create a burden to this honorable court, since the matter is also pending in the Nalbari trial court. And your lordship, if I may be permitted 2 minutes, I can convince you why this matter should be, an interim relief should be granted today itself. A corruption charges, on the basis of a corruption charges, a money suit has been filed in the trial court, your lordship. That to the principal has no authorization from the department. The principal during the amicable settlement came to us stating that you should withdraw your case if we can furnish an amicable settlement, your lordship. The principal is retiring in 2026, your lordship, and one of the members of the auditing committee, Srimati Vijayakar, who initially had done the AG report twice after I was transferred to a new location from Kajalgaon. I was from Nalbari. I was transferred to Kajalgaon. She had done the AG auditing twice, your lordship, and then again she sat in the very committee which only furnished an inspection report and not an inquiry order, stating that there were some discrepancies. Your lordship, they've also filed a written statement in the honorable trial, and if I may be allowed to furnish this to you, your lordship.
So, you say, this matter was first listed on 19/2/2025.
Yes, your lordship.
There is no pair for this, interim relief.
Yes, sir. No, we prayed. There was an oral prayer made to this honorable court, your lordship. Nothing in written, because the honorable court had stated that, and because the honorable court had stated that the matter is still in the trial, let us wait till the next date. That was what the honorable court had told us. Now, your lordship, after we came to the high court, just as a retaliation, a money suit was filed without an order being given by the director to the principal in the honorable trial, your lordship. Now, I'm not sure how retaliation can be a part of this court, and it is just creating a burden and wasting time to this.
Sir, let her file her affidavit.
Your lordship, if an interim relief, your lordship, if he may be reinstated back into the position, if I am found guilty, I will be the first one to submit a resignation, your lordship, if that may be allowed, your lordship. I have been out of job for 605 days, your lordship. I have a family to cater to, 2 young children, that too 1 year old. Your lordship, I have a twin.
Okay, all right. Let her file her affidavit. We'll take a final vote on the matter.
Your lordship, a
Actually,
date
we'll
may be
decide
fixed, your
tomorrow.
lordship. A date may be fixed, your lordship.
We'll fix the date. Her, Mr. Your good name, please.
A Das, your lordship.
Is the, petitioner and next,
Canberra.
and Cora, Garden is something counted for
Yeah.
RD department. It's Cora submits that. Your name is not there.
Yes, your lordship. I've also prayed in front of this registry. On a personal note, I have been appearing in front of this honorable court for 4 times now. My name has not reflected in the
Okay.
list. It may be allowed, your lordship.
Cora submits that she has received the instruction today, and she will bring the same on record by writing an affidavit. And price for granting her 1 week time,
Yes, your lord.
1 week time, fair is allowed.
A date may be listed, your fixed, your lordship. I have to come all the way from Delhi, your lordship.
Okay. Can it be on 24th?
24th, yes. Yeah, 24th, yes, your lordship.
Okay.
Yeah.
24th of October. Mr.
24th.
Duff,
Yes,
the
your
next council for the principal submits that despite his request, the registry has not reflected his name in the office. This is the Buddha need to fix that this record.
much obliged, your lordship.
24,
24th October. October.
family is no time.
Lordship, 126 days. I'm not sure how more time can be granted. 196 as per the records.
They I have received that.
Your lordship, 196 days have passed. 126 on records minus the official holidays and other dates. I'm not sure how more time can be granted, your lordship. 24th.
Can it be on 3rd of November? 3rd November.
Yes, your lordship. Yeah.
3rd of November.
Thank you. Much obliged, your lordship.
For bail hearings, item 13. Made period. It's a charge sheeted case, my lord. Here the petitioner was arrested on, my lord, 13/1/21, my lord. And the charge sheet was laid, my lord, on 7/1/22, citing, my lord, 13 number of witnesses, my lord. Till date, my lord, only eight witnesses have been examined, my lord. Nine, sorry, my lord, nine witnesses have been examined. And I am praying bail in this connection, my lord, on the ground, my lord, non-furnishing, my lord, of the grounds of, my lord, arrest, my lord. Section 50 and 50A of the CRPC. Behind that. Notice from behind. Nice.
Okay. So out of 15 witnesses.
13, my lord, 1 3,
13.
my lord, 13 witnesses,
9
Nine.
have been examined.
9 have been examined. And my
So whether the copy of the arrest memo and inspection memo and the notice are the part of this record?
no, my lord, as because my submission is that, my information, my lord, no notice under section 50 and 50A of the CRPC has been served upon the petitioner.
So where is the averment need to be?
My lord, I have made the specific averment, my lord, at pay at paragraph 8, ma'am. Page 7, paragraph 8. Not to reply. May I read, ma'am?
Not necessary.
My lord.
Yes, Mr. Kyle,
Lordship,
how do you respond to this submission?
Lordship, we file our objection in this case. Lordship, first my submission is that earlier they approached this honorable court and their bail application was rejected. The order was filed by them by additional affidavit. Page 130,
Rejection of
142.
additional affidavit.
Yes.
It was rejected on 4/2/2025. At the relevant time, Lordship, no, this ground was taken by them.
No, that can be taken at any stage.
Lordship, that can be
There is
taken.
a
Lordship,
bar.
in our affidavit, we have, Lordship, please to see
Paragraph 9.
paragraph 3 and 9 and 3 and 9.
Page number?
Page, Lordship, there is a mistake in page, it is 140.
140.
Lordship, there is a duplicate in the.
140 is the additional affidavit filed by the petitioner.
But there is a
There is a mistake in
mistake.
definition.
pagination is
Or affidavit, there may be lordship for then it may be 158. It starts from 148. 149, it may be 149.
Wait,
can I give this copy? If it is like you will be access for answer.
yeah, got it, okay. Paragraph number 3 and
3 and 9 go.
9. So page number 48 is the memo of arrest.
Lot.
Yes.
And where is the copy of notice?
Notice is separately not there. But what's the paragraph 9, last 4 lines. The legislative intent of section 50 and 58 of CRPC is served by arrest memo as a ground of arrest and information about the arrest of the family member have been duly complied.
No. In order to substantiate that statement and environment, you have to produce the copy of the notice.
Lordship,
Where is the notice?
no, notice is not there. Lordship, I am relying on one judgment of Honorable Supreme Court, that is in case of State of Karnataka versus Sri Judgment. Paragraph 20.1, page 18.
Twenty point one.
20.1, delay in furnishing ground of arrest cannot be itself constitute a valid ground for grant of bail. Merit.
No, that's all right. But is it your stand that later on you have furnished the ground
No,
of arrest?
No,
That's
Lordship, that's why I am relying on these aspects. Okay, please to consider. Although Lordship, my learned friend comes with a judgment of reasonable court which says that Dhyan Kumar will be applicable, this judgment not be applicable. Recently, one judgment has been passed by Honorable Supreme Court, where it is stated that if there is a true judgment on the same subject, then court has to consider all the judgments, and if the judgment is better, that to be taken into consideration.
which is the better?
If the judgment which is better, that should be taken into consideration.
Where it is that?
Lordship, yes, paragraph, I remember the
No,
number
no,
of paragraph.
in view of the decision of the Honorable Supreme Court, the constitutional bench pronounced that day.
Yes, Lordship, that, Lordship, in that case, paragraph 35, so Supreme Court says that if the Arun Karim judgment is there, then earlier judgment will be applicable. Lordship, in this judgment, all the previous judgment has been considered. You can consult case, Dhyan Kumar's case, Lordship, may please to see paragraph 20.1.4.
This is our division bench judgment, my lord, paragraph 15. Paragraph 15. Relying upon the Pranay Shetty judgment.
If Lordship, it is correct, I am not disputing that aspect of.
But while considering the judgment of Sethi's case, probably it was not properly considered. Paragraph 35 of that judgment, Pranav Sethi judgment, it says that if the judgment is Korean, the subsequent judgment is Korean, it is not considered earlier judgment, then previous judgment will be considered, will be taken into consideration in the basis. But here Lordship may please to see in judgment case, all the judgment of the previous and Parveer Prukasta, Dhyan Kumar and Bansal's case, all cases has been taken into consideration. Lordship please to see paragraph 20.1.4.
Yes.
In Bihan Kumar versus State of Haryana reported in so it was reiterated that Article 22(1) is satisfied if the accused is made aware of the arrest ground in substance, even if not conveyed in writing. Similarly, in Kesareddy Upendra Reddy versus Andhra Pradesh, it was observed that when the arrest is made pursuant to a warrant, reading out to the warrant amounts to sufficient compliance. Both these post consult decision clearly stated written and individualized grounds are not to be inflexible requirement in all circumstances. And next, while section 50 of CRPC is mandatory, the consistent judicial approach has been adopted a prejudice oriented test when examining arrest procedure lapses. The mere absence of written ground does not effectively render arrest illegal unless it resulted in demonstrable prejudice or denial of a fair opportunity to defend. Then paragraph 20.1.6, the High Court, however, relied heavily on the alleged procedural lapses as determinative factor while overlooking the gravity of the offence under section 302 IPC and the existence of prima facie case. It is noted that inter alia there has no mention in the remand order about service of memo of ground of arrest. The arrest memo were allegedly template based and not personalized. An eyewitness has not stated that they were present at the time of arrest or signed the memo. Relying on the Pankaj Bansal versus Union of India and Parveer Prukasta versus State, it concluded that that from 3/10/2023 onward, failure to serve detailed, written and individualized ground of arrest immediately after arrest was violative in entitling the accused to bail. Paragraph 20.1 this is important. In the present case, the arrest memo and the remand order clearly reflects that the respondents were aware about the reason for their arrest. They were legally represented from the outset and applied for bail shortly and after arrest, evidencing the immediate and informed understanding of the accusation. No material has been placed on record to establish that any prejudice was caused due to the alleged procedural lapse. In absence of demonstrable prejudice such as irregularity is best, a curable defect cannot be itself warrant release of accused on bail. As reiterated above, the High Court stated the determinative factor while overlooking the gravity of the charge under section 302 IPC and existence of prima facie case. It relies on Pankaj Bansal and Parveer Prukasta is misplaced as this decision turned on materially different facts and statutory context. The approach adopted here is inconsistent with the settled principle that procedural lapses in furnishing ground of arrest absent prejudice do not expect to render custody illegal or entirely accused to bail. Here, Lordship, the accused has come for bail in two occasions. One before London Trial Court, another before this Honorable Court. And that has been placed before Lordship by filing an additional affidavit in my land. It was not that they were not aware of why they were arrested. And it consists of they were arrested while they were getting the conscious position of the contract. And
While the earlier two bail applications were dismissed by this court,
one by this one.
Dhyan Kumar's judgment was perhaps not there.
No, it was not taken. It was not placed.
That judgment was not pronounced perhaps at that point of time.
No, Lordship, they have not taken this ground up. Before either before the London Trial Court or before this one. This ground was not taken for.
So, Mr. Kayal, you are admitting that except the statement made in your objection application,
Lordship.
There is no material to suggest that you have furnished the
Lordship,
ground of arrest in the
arrest memo is there. That is contained.
arrest memo. Is it mentioned in the arrest memo?
Yes, Lord.
Where?
To see in my additional, my affidavit, objection.
My
Yes.
petition itself, page 131. Page 131.
No, arrest memo is page number 146.
He had an ex, and I had also annexed it in my petition, page 131.
Let us go through his affidavit.
My lord,
Where it is stated.
my lord,
No,
It is same Lordship. Married Lordship.
Yeah.
Page 131. Arrest memo of Sri Chandra Joy Jamatia, son of permanent arrest, son of Sri Chandra Jamatia is hereby arrested by me at 14 hours on 13/1/2021 under section 42 NDPS Act 1985 on the reasonable belief that he has violated provision of section 8C of NDPS Act and thereby committed an offence punishable under section 20B 2C 22, 27, 29 of chapter 4 of NDPS Act. He has been duly appraised the ground of his arrest, and his arrest had been intimated to his wife, Srimati Chandra Prabha, by phone. Brief text of the case, acting on specific information, a truck bearing registration number so at National Highway 37 near Kanapada flyover bridge on 12/1/2021. On checking of the state truck, 17 packets weighing 107 kg of gross weight of dry plants leaves with flowering top reasonably believed to be ganja were recovered from the specifically full secret cavity behind the truck of the said truck number truck 1078 was the ganja along with 10 wheel truck were seized by DRI case number so for contravention of the provision of section 8C of the NDPS Act. The said person, particulars of the persons arrested, name is there, father's name is there. All these lordship details are there. So in my humble submission, lordship, all details are contained in the arrest memo, and he was informed separately by the arresting authority. So in my humble submission, lordship, there is a sufficient compliance of section 50 or the provision of law. When in case of lordship, Kabir Prukasta and the Dhyan Kumar also, lordship is observed by this honorable court in paragraph, honorable Supreme Court in paragraph 20.1.3. That lordship, paragraph 20.1.4 of Sri Darshan State. Sri Darshan State. And state of Karnataka versus Sri Darshan. Paragraph number? Paragraph 20.1.4.
Yes.
In Dhyan Kumar, it was stated that the arrest article 22(1) is satisfied if the accused is made aware of the arrest ground in substance, even if not conveyed in writing.
Yes, Mr. Doctor.
my lord, only one submission, my lord. Lordship had gone through the, my lord, the arrest memo, my lord. If the lordship pleases, my lord, lordship kindly have a look at the CRPC, my lord. Section 41B, my lord, for a once. 41 capital B. Procedure of arrest and duties of police making arrest. My lordship found it. My lord, there, my lord. B, my lord. Prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. So now if your lordship sees the, my lord, the arrest memo, there is no signature of any witnesses. And now, my lord, lordship now turn to, my lord, section 60 capital A of the CRPC. Arrest to be made strictly according to the code. No arrest shall be made except in accordance with the provision of this code or any other law for the time being in force providing for arrest. So 41 capital B subsection B is not
So,
followed in this
Sir,
case.
Doctor, here you are not challenging the arrest.
Yes,
You are praying for
we are
bail.
praying for bail, my
That
lord.
the ground of arrest has not been
Yes, my lord,
communicated to you.
that much.
But in view of this memo of arrest, appears that the ground has been communicated to you.
Yes, my lord, but this,
Your this some impression is there.
yes. And the second part, my lord, 50A, my lord. 50A, that grounds of arrest has to be communicated to the family members. my lord. In the instant case, my lord, they have not done so. And from their affidavit, my lord, they have stated in paragraph 9, my lord, he has been duly apprised of the ground of his arrest, and his arrest has been informed to his elder brother by phone, my lord. Yes. And I am relying our division bench judgment, my lord. That, my lord, National Investigating Agency versus Thangling Mete, my lord. Paragraph 15 and 16, my lord.
No, if we go by the judgment of Honorable Supreme Court, it is state of Karnataka versus Dorset,
My lord,
especially in paragraph number 20.1.4.
my lord.
There it is stated that Article 22(1) is satisfied
My lord.
if the accused is made aware of the arrest grounds in substance, even if not conveyed in writing. Going by the arrest memo, which is annexed with their
Yes, my lord.
objection petition, can it be said that the ground of arrest has not been communicated to you, though not in the form of a notice under section 50 of the
My lord, assuming but not admitting that is a grounds of arrest in arrest memo.
Yes.
Now the question arises whether these grounds of arrest has been communicated to my family member. So the division bench of our High Court held, my lord, in that case, my lord, Mia case, my lord, it has held, my lord, it was not communicated to the family members. So 50A should be complied with. 50A of the CRPC should be complied with. And in that division bench judgment, my lord, although the grounds of arrest was communicated to the family members, there was only a signature. As because the date is not inserted, so that's why also, my lord, that it was rejected, my lord. Paragraph 17, my lord.
Yes, Mr. Kyle, how do you respond?
Lordship, at place, Lordship, regarding Lordship that citizen raise or High Court judgment. It says that earlier judgment will be prevailed. Lordship, I am relying on, reading on, I'll supply copy of the judgment. Paragraph 35. Lordship, the name of the case is AP Electric Equipment Corporation versus Tahsildar.
What is the citation?
2025 0 Supreme SC page 407. 2025 0 Supreme SC page 407. Paragraph, I'm relying on paragraph 35. I'll supply copies to
What
Lordship,
is the strength of the bench?
Lordship, the two judges. Lordship,
Three is of 5 judges.
Yes, my lord, 5
Lordship,
dozen.
here, Lordship, that's why I'm pleased, Lordship, please to see the cities, paragraph 35, what it says. It was not properly considered by our High Court. And Lordship, in paragraph 35, if two decision of this court appears inconsistent with each other, the high courts are not follow one and overlook other, but should try to reconcile and respect them both. And the only way to do is to adopt the wise suggestion of the Lord Salisbury given in so and so, so and so. Every judgment must be read as applicable to the particular fact, proved or assumed to be proved. Since the generality of the expressions which may found there are not intended to be exposition of whole law, but governed or qualified by particular fact of case in which the expression are to be found. I'll supply copy to Lordship for consideration. And Lordship, paragraph 35 of Sefi's judgment may Lordship may please to see what it says. What I have
But
understood.
I don't think that a decision of two judgments can override the decision of overrule the decision of a constitutional.
No, Lordship, Lordship may please to see, there is a, Lordship can differentiate while reading out the paragraph 35 of Sefi's judgment. I know Lordship, judgment of larger bench is prevail over, but Lordship, the purview to Costa and Ihan Kumar, all are up to judges bench. It's correct that there is judgment of our high court, but there is a scope for interpreting the judgment. Because our high court has relied on the constitutional based judgment in Sefi's case, but Lordship, it was not properly raised. Rather, I will say
If
Lordship,
properly not made, you go for appeal.
no, Lordship, it was not in our case, it was in your case. But my duty, Lordship, to place before your Lordship the correct position of law. Lordship, consider if Lordship convince Lordship, because the similar matter is pending before division bench. Here I am taking this point, Lordship, but hearing is fixed on 23rd, right? My friend is also there. In that case also, Lordship, this ground has been taken, non-compliance of 50 and 58.
Okay, we'll pass the order.
Well, I'm obliged.
Lordship, may I refer to submit that judgment?
Yes, you can forward it to the person side.
No, Item 14.
May it please your lordship. Lordship may kindly peruse the last order passed by your lordship. They took time to go through the Ms. Tina judgment, lordship.
Okay,
That
Mr.
whether
You have got through the same.
Regarding in her judgment, yes, otherwise, my lord, I am aware about that judgment, my lord, regarding that. But here the ground taken by the petitioner is that non-furnishing of the, my lord, grounds of arrest, my lord, in writing. So that is the ground, my lord, he has taken regarding retrospective effect, my lord, that if he wants to place that judgment, my lord. So Mr. Petitioner judgment, that is the judgment of the, my lord, concourse is, my lord, earlier than the constitution. So in view of, my lord, Constitutional judgment, then in that case, my lord, if you want to place that, my lord, in that case, my lord, concourse judgment is applicable.
apart from that, lordship, another judgment I'm placing before your lordship. Here, lordship, that although it is a Karnataka High Court bench, but I'm relying on because this order was challenged before the Supreme Court. And therefore, I'm placing lordship that in Karnataka High Court, lordship, that your lordship also relied on that Harikishan judgment in Farooq's case, lordship, which I have earlier date placed. And so on similar judgment, lordship, it was held that it will be retrospective. And that order was challenged. That your lordship will find.
Okay. We'll pass the order.
Lordship. And that Supreme Court judgment also I have given lordship, wherein lordship no stay was granted, although it was said that this order will be placed as a precedent, lordship. Considering that Supreme Court did not grant any stay order.
My lord, I have regarding that grounds of arrest, everything is, my lord, already in the petition already here, and I have also flag mark is also there. But I would just like to point out one thing, my lord, not only grounds of arrest regarding the conduct of the petitioner while approaching below, because my lord, in this case, my lord, earlier this bail petitions were rejected by this honorable court. That is, thereafter, my lord, he approached before this, now approached before this on the grounds of, my lord, non-furnishing these grounds of arrest in writing. Before that, my lord, he approached the petitioner, approached before the honorable Supreme Court.
on 19/8/2025, he has withdrawn that petition from the Supreme Court. Thereafter, my lord, the present petitioner approached before the, my lord, Honorable Session Judge by way of the, my lord, filing bail application. In that bail petition, my lord, although that bail petition was rejected by the Honorable Session Court, but at that point of time, there is no mention about that withdrawal of the, my lord, that bail petition before, which was filed before the Honorable Supreme Court. Although here, my lord,
After withdrawal, it was done. After withdrawal of that Supreme Court or application, lordship, the application was filed because co-accused was granted
And-
bail by the trial court.
and at
So
any
it was
point of time, my
instructed.
lord, in before Supreme Court, but before the Session Court, my lord, Session Court, my lord, he has filed this bail application on 29/8, that bail petition was nowhere, my lord, he has read all these grounds, my lord, earlier, my lord, now he has, my lord, for the first time, he has taken all these grounds before the Honorable Court.
All those orders I have enclosed with my application, lordship. I have not suppressed any material.
But, Sir Protector, admittedly, the lot of arrest has not been furnished to him. Devappa, I am for respondent number 2, my lord. My senior is in bereavement. Okay, so matter may be fixed on 28th. 28th. You see, the purpose of listing the matter today, when RSA is filed against the decree of ejectment under Assam Urban Area Rent Control Act, there is no appeal, no provision for second appeal. So the question
That
is.
I am not
is-
aware of, my lord.
Pardon?
That I am not aware of, my lord. So matter may be taken up on 28th. I am praying for a date.
None appears for the appellate court. How about this, sir?
Yes, Upaധ്याय. I am
But
appearing on behalf of NN Upaധ്યાય.
Appellate of the appellate for the NN Upadhyay. Take the matter of 28th. 23rd, my senior won't be there. He is out of state as his father-in-law expired. On 28th,
Yes.
this court will not be sitting here.
Any date, my lord, after 28th, any date.
Then, uh, third of November.
I am deeply obliged, my lord.
That's fine.
My lord, the fact of the matter is, nothing has progressed. Every time they say something,
We have received the document here, sir. Proposal has been, after conference, the proposal for sanctioning 23 crore 62 lakhs has been accepted. On 13th date.
No, my lord, this is a shuttlecock business happening between health, finance. These are typical, my lord, finance department language. Trying to hoodwink everybody. They are support, this reappropriation, contingency fund, then my lord, budget proposal, we are listening this for the last 4 years. They should pay. They're building bridges all throughout the city. Where are the money is coming? Why can't you pay 23 crores? And that to pensionary benefit of people, of employees? These are all juggleries. They're using expression just to tide over the situation. Let us, see what happens tomorrow. We'll think about day after tomorrow later on. Either they should say they are not in a position to pay, then let this government give up. What is happening, my lord? The pension for the last 5 years we are fighting. Someday they will say we have sent a reappropriation proposal. Sometimes they say you send us a contingency fund proposal. Sometimes they will say we have sending given budget proposal. End of the matter, nothing is happening. I think, my lord, let the finance, principal secretary finance appear and explain the conduct, my lord. Why this order has not been implemented. There is limit to everything. Kindly see, I think Lordship is monitoring the matter for the last almost a year now. Prior to that, many coordinate benches have done it, but nothing has happened. We are getting area, we have received only 10% of our area. We all know how a budget is passed. If we look at Article 200 of the Constitution, we all know how a budget is passed. Now tomorrow finance department might raise another objection, as they're in the habit of doing it in everything. You are taking loan after loan, lakhs of crores of rupees you are taking loan. You have no money to pay pension.
This penultimate paragraph is the according to the director of higher education submitted.
Well, had it been a case where matter is being debated for 1 or 2 months, there is absolutely my learned friend is correct. But everybody will have expectation. People are dying. Members of the association are dying. They're not receiving anything. If you have the will, you can always certainly make some budgetary provision for this payment. And that too, Lordship has given them 3 installments, not in 1. After payment of that part payment, Lordship has given them 3 installments. And every time a letter is coming only. And
Pardon?
No, I think my learned friend said should have the instructions when he will make the second installment. No instruction. When they are going to make the payment of second installment.
October.
Let it be on 24th.
Let the finance secretary come personally.
Yes.
Explain. No, yeah, you are a party here now.
Those technicalities are there. That Lordship, the power of the court's hand are big enough to ensure his presence. Whether there is a party, whether it is not a party, these are all technicalities. Writ petition and contempt proceedings arising therefrom are not bound by any technical consideration.
Is there oh, say. No, earlier there was a direction to the finance department also to ensure the availability of funds for payment of the amount. Now, Mr. Goswami, you see whether this 23, 362.71 lakh will be sufficient to make payment of the entire area amount to the.
No, no, what we say around is 82.16 crores. What will be the last? Is it? Further, the remaining amount.
So, even after issuance of repeated direction, you have not forwarded the proposal.
Yes.
What?
So you see last.
Education. Yeah.
The government of Assam is one. As far as.
24, let me come up there, thereafter don't take a call. Yes. Well, the new development is. Yeah, but it's. Because my lord, Monday and Tuesday is the holiday. That's why I'm saying for price. Diwali also. So all.
Oh, why not 22nd?
Yes. এখন
More is only the work.
You will only update the verbal instruction over.
So, content case, I will say that afterwards, tomorrow, they will say no, because of the statement they have made out of this. So, let's see. But otherwise,
No, sir, Gogo, you see, this order was passed in the year when.
2021.
So some persons already suffered the fine.
25. Or 24.
All let it be 24th million.
Okay, so
ठीक है सर
for the
Question number 4.
number.
Question number 4.
Number 4, that's coming for. Number 5, that's the logo 4. Number 10. There is the court of hearing, the solicitor has produced some letters. Of Joint Secretary to the Government of Assam dated 13/10/2025. Wherein it is stated that in respect of the remaining amount of rupees 58,850.23 lakhs, the department is in the process of moving a separate CF proposal which will be submitted to the finance department for review. So the question is, proposal is yet to be submitted to the finance department.
So, for instance, letter is concerned, but they stated well that 20 crores. So, there is the remaining. That is a para, last para, second para, and the last. The last second para, same para, same possibly.
So wherein it is stated that the higher Director of Higher Education Assam submitted a appropriation proposal amounting to 1,362.71 lakh, which after concurrence of competent authority has been forwarded to the finance department to the Senate. And respect of the remaining amount of rupees 5,850.53 lakhs, the department is in the process of making separate CF proposal with self-satisfying for consideration and sanction. Mr. Gogo will learn it counsel for the respondent number 3. Submits that immediately granted working days to
So, whether the unit of finance department.
finance department submits that he may be granted to work in trade
কিনা
and
ইমপ্লিস করে
to obtain
ফিনান্স
subscription with respect to the information letter of the Judge Secretary to the Dr. Vasa Fire Police Department.
পুরা একটা ফোন করে
There is a
জামাই
good
বলা
allowed this the matter on the heard. On that day, Mr. Gogoi said on the written instruction. Yes, with respect of it's 162.71.
I have taken 24. I have taken.
Okay, let it be 24.
Oh, okay.
Yes, yes.
I cannot give consent anyway. Deep level.
17.
Lovely. Your instruction is technical issue today. Okay, monitoring is a for long time, let's say they have 10 inspection.
So whether it is rectified now, Mr.
Whether meeting was called for or not, that cannot be certain. So my lord may fix it on 23rd or 24th. Because a meeting was called for a SLC, PC meeting was called for. Yeah, whether that was happened or not, I cannot ascertain. That is the matter on next week on 23rd or 24th.
Okay. Third, Mr. AE Ahmed, optic for the optic for the response. Third one. Third for the letter, it is 5. The secretary to the Dr. Vasa Department of Education. And some extent due to technical issue. The e-office server has it not functioned take it of it. Right. As a result of which the department is asked to use the file and transfer the transfer or download the update that part is the liquid instruction. To apprise this for and others are press for listening the matter either on the part 22nd or
23rd minute.
there are not this the matter 23rd as part of.
Items for hearing. Item number 18. Partner.
My lord, on the last occasion, my lord has directed us to obtain some judgment, my lord, and judgment in respect of release of area salary.
Your Lordship, actually, my senior AK Bhuya has been recently engaged as the new standing counsel of PCC. So we don't have any relevant document with us.
My lord, BTC has already filed affidavit, my lord. There has no role, my lord, because it is under the jurisdiction of courts of Assam, my lord. They have already filed their affidavit.
Your Lordship, BPC has a role. Because the teacher is under the jurisdiction of the PT. Now, if at all the payment has to be made, it has to be made by the PT. Therefore, it has definitely a role, BPC.
They have filed their affidavit, my lord, stating that there is no role, my lord.
Now, they have been newly engaged.
And my lord, the matter is of 2016.
Perhaps
my lord.
process may fix after a week or so. Copy may be furnished.
What copy?
The petition copy and everything, we don't have any relevant document with us.
They may collect our hardstyle concept.
It will be problematic for us. It will be problematic for us. If they can furnish a
It
copy.
is your business. Why should each and every time council for the petitioner will furnish the copy to you? Have the copy.
My lord, we need to prepare the copy, my lord.
What's the copy? Well, let it be on 23rd then.
Yes, my lord.
28, for 1 week this court will not visit. Third Mr. DK Roy, learned at council for the petition. Sir,
P. Bhumi.
P.
P. Bhumi.
P. Bhumi, learned at council, debate on behalf of the DK. Learned at standing council for the respondent DK. Then Mr. Sarma for respondent number 1 and 2. 1 and 2. Mr. Bhumi, some extent. Mr. AK Bhuya is recently engaged as standing counsel for BTC. And he has not been furnished a copy of the petition. And he pressed for listing the matter after a week. And also pressed for directing the petitioner to furnish a copy of the writ petition to him. Where is allowed basis at the petitioner on 23rd. Then the meantime, Mr. Roy learned for the petitioner to furnish a copy of the petition to Mr. Bhumi, if possible during the course of the day.
Yes, my lord. The matter may be kept as a part of matter.
Okay, that's the matter. Part of.
Item 19. Order member.
May it please the lordship.
So, what the appellant?
I am the appellant, lordship.
What is the ground?
Lordship, the award is for a very small amount, 1,10,000. It's an injury case.
What
But
is
the
the
ground is that the company's there was that there's no policy was issued. The claimant had enclosed a copy of a cover note, lordship. Cover note is one of those documents which are issued temporarily, which is substituted subsequently by a policy. Yes, no one asked for a cover note, even the police, and it's not a mandatory. But certificates and policies are very important. So, lordship, that was the bone of contention, lordship. The vehicle was, according to the insurance company, no policies also. They checked the entire record. They are issued from Ahmedabad. It had come with the, let's say, cover note issued probably by the dealer. Ahmedabad office had probably had sent them the. So from Gujarat it came.
Cover note was issued by the dealer.
From dealer, lordship. I have said, checked the EA.
Then the dealer
It
has
bears
also-
the seal of Ahmedabad office. An office from Ahmedabad.
Okay.
The insurance company obtained a confirmation from that office. It's all there. It's a bunch of huge bunch of entire premium register has been sent by them to show that no such policies are issued by them. No such policy means it has policy is not there. They said no policy in the name of so and so. That to prove that they send the entire is a huge bunch of records. To show that no, this vehicle was not insured.
But you admit that cover note was issued by your company.
That part is in silent, lordship. I have to admit, lordship. Insurance company did not say anything because they did not have the EA. If they had the cover note, they would have probably
The
also
cover-
sent the EA.
Usually the cover note is issued after receiving the premium amount.
That's right. That's right. It's a temporary document, lordship, which is usually replaced by, it has to be is there, it has to be replaced by a policy. Policy is the document which is EA, and cover note is a temporary, we hold it covered. You go home, take the vehicle, we hold it covered. Maybe because it was to be issued from Ahmedabad, they would have probably issued. No, point is there, lordship, I am on a different point because I agree to your lordship. There is no such strict denial that this cover note was not issued. I have gone through that record. That there should be a specific denial also at the same time. This cover note was not issued by us. But at the same time, Lordship, I'd like to draw your attention, Lordship's attention to just 2 points, Lordship. Maybe it's as if a rational principle that can be used. Here, Lordship, the best person to have countered my A is the owner of the vehicle. Claimant would not have a clue about whether the policy covered or is genuine. He has submitted it, got it from police, given it. So I will not hold him responsible if he cannot say anything about it. But the owner of the vehicle who was made a party did not say anything about it. Lordship, there are two citations, two decisions of the Supreme Court on this particular point. That what are the duties and obligations of the owner of the vehicle when a case is Lordship. I'll just rely on Lordship these two, just to draw your, if Lordship can. It can. These are very important decisions and I use them quite often, Lordship. It's on driving license. There's another one on permit on similar to what the owner should do. Para number 13, Lordship. After the Lordship, I'll leave it to your Lordship to take a Lordship. Just to draw your para number 13.
Okay.
This is regarding driving license. In the present case, the respondent number 1, may I read that also? In the present case, the respondent number 1, owner of the offending vehicle, merely raised a vague plea in the written statement that the offending vehicle DIL so-and-so was being driven by a person having a valid driving license. He did not disclose the name of the driver and his details. Besides, the respondent number 1 did not enter the witness box or examine any witness in support of this plea. The respondent number 2 insurance company in the written statement has plainly refuted the plea that plea and also asserted that the offending vehicle was not driven by an authorized person and having a valid driving license. The respondent number 1 owner of the offending vehicle did not produce any evidence except license, except driving license of one Joginder Singh, without any specific stand taken in the pleadings or in the evidence that the same Joginder Singh was in fact authorized to drive the vehicle in question at the relevant time. Only then would owner's shift, requiring the respondent number 2 insurance company to rebut such evidence and produce other evidence to substantiate its defense. Merely producing a valid insurance certificate in respect to offending truck was not enough for the respondent number 1 to make the insurance company liable to discharge his liability arising from rash and negligence driving of the driver of the vehicle. The insurance company can be fastened with the liability on the basis of a valid insurance policy only after the basic facts are pleaded and established by the owner of the offending vehicle, that the vehicle was not only duly insured, but also that it was driven by an authorized person having a valid driving license. Without disclosing the name of the driver in the written statement or producing any evidence to substantiate the fact that copy of the driving license produced in support of the support was of a person who in fact was authorized to drive the offending vehicle at the relevant time, the owner of the vehicle cannot be said to have extricated himself from his liability. The insurance company would become liable only after such foundational facts are pleaded and proved by the owner of the offending vehicle. Maybe Lordship, I could not. Maybe it's a very old document. At that time, some handwritten document. Now it has become computerized. Maybe it because of mismatch. I'm just admitting what probably ought to have been here. I'm admitting my problem. But at the same time, this does not allow the owner of the vehicle to go exonerated. This is what it says. After they own, because what it's taken so lightly by the owners of the vehicle, they don't even care to bother to appear. In most of the cases, 90% of the cases, owners do not appear. Lordship. It's time the Supreme Court has rightly taken cognizance of this fact. He has to plead and prove the foundational facts that the vehicle was not only insured, it was also being driven by a person who held a valid driving license. After I take the pleading, I have given the evidence here. I think as per this year, only pleading is sufficient. If I take a pleading, he has to counter it. And in this case, I have come out with all whatever materials I had to deny. Lordship, it's a huge bunch.
We did not, miserly evidence was not there. We did a lot of hard work, Lordship. It was completely. Apart from there's another decision supporting this point of view about owner's liability, obligations. This is on permit. I'm giving a copy of this one.
So, Mr. Swami, you see,
Yes, ma'am.
if the vehicle is insured with the
Yes.
insurance company, why the owner will go to the court and pay the advocate's fee and file the written claim?
That is what they should be doing. That's what the owner, Supreme Court has clearly stated this only. So why should owner be extricated? He has a duty to come to the court, plead his facts.
No,
No,
perhaps,
that's what says. That's because he has an insurance policy, he cannot be exonerated. That's the Lordship, Lordship, if I read this para once again, Lordship, the sum and substance is this. The insurance, just because they have an insurance policy, does not make them exonerated. They have to prove that they, a duly licensed driver was, that's the sum and substance of the.
Mr. Goswami, that question has to be, that issue has to be percolated to the ground level.
Now, this is the way it will go, Lordship.
How?
This 1,10,000 will not cripple any person. But this message will go. The owners, you have to come and participate. It's a legal process, judicial process. How long will the courts, Lordship, tolerate this kind of, they don't even bother to come and respond, Lordship. They have, as a dutiful citizens of this country, they have a duty to cooperate with the court. Court has called them. They should come and say, this is my insurance policy, this is my driver's license. He held a proper driving license. This is what the Supreme Court is trying to Lordship, instill in the This kind of messages should be spread, Lordship. So this is the judgment, Lordship. Another one that says the same thing, Lordship.
Mr. Goswami, ground reality is quite different.
Lordship, but
Courtroom.
no, this is a bad practice that has to be, Lordship,
That's all right.
has to be dealt with, Lordship.
We are all agreeable to the bad practice.
No, Lordship, but then I can take a legal ground, Lord, legal defense that he should come and take his. Otherwise, they'll never take license. They'll say, yes, but
Okay.
I did not,
You
don't
give
even.
me your other judgment.
Other than this, Amrit Pal Singh, Lord, it's on permit. Similar point of view, Lord.
Okay.
Two different benches, two different points, similar point of view, Lordship. I'll
Okay.
read out this particular paragraph, para 24. After the Lordship, I'll leave it to your Lordship. I just wanted to make a point, Lordship. Para 24. May I read, Lordship? Para 24.
You can read it.
Yes, sir. In the case at hand, it is clearly demonstrable from the materials brought on record that the vehicle at the time of accident did not have a permit. The appellants had taken a stand that the vehicle was not involved in the accident. That apart, they had not stated whether the vehicle had a temporary permit or any other kind of permit. The exceptions that have been carved out under Section 66 of the Act, needless to emphasize, are to be pleaded and proved. The exceptions cannot be taken aid of in the course of argument to seek absolution from liability. Use of vehicle in a public place without a permit is a fundamental statutory infraction. We are disposed to think so in view of the series of exceptions carved out under Section 66. The said situations cannot be equated with absence of license or fake license or a license for different kind of vehicles, or for that matter, violation of a condition of carrying more number of passengers. Therefore, the principles laid down in Saran Singh and Lakshmi Chand in that regard would not be applicable to the case at hand. That apart, the insurer had taken the plea that vehicle in question had no permit. It does not require the wisdom of the Tripitaka that the existence of a permit or of any nature is a matter of documentary evidence. Nothing has been brought on record by the insured to prove that he had a permit of the vehicle. In such a situation, the onus cannot be cast on the insurer. Therefore, the tribunal as well as the High Court had directed that the insurer was required to pay the compensation amount to the claimants with interest and the stipulation that the insurer shall be entitled to recover from the same from the owner. The said directions are in consonance with the principles as stated in Saran Singh. Another. Lordship, what again the same, nothing has been brought on record. The owners cannot be shifted, cast on the insurer. This time the owner of the vehicle had come, Amit Pal has, he was not given that exoneration from liability. That pay and recover will stand. He cannot exonerate himself because permit is a documentary event that he has to do. These two decisions, Lordship, seem to bring about some disciplinary measures in the owners of the, inculcate some disciplinary, Lordship. That they should also come and, like responsible citizens, come and cooperate before the court, Lordship.
Yes. You are for?
I'm appearing for the honor lordship.
Owner.
Honor lordship, but I want to identify two issues. First, my senior friend has bifurcated from the issue lordship. I being the after receiving the notice, I duly appeared and submitted my DW lordship. And after hearing all the parties, this order has been passed lordship. And the thing is, appeared lordship. I think that
You have filed a written statement.
yes,
or
lordship.
you adduce evidence as.
yes, everything.
No,
I have W has been
No,
submitted,
no.
lordship, before the court.
Fair line. No, it is. Opposite side did not reduce any.
Yes, lordship. Everything I have given what
But you have filed your
Yes, lordship. And secondly, lordship, in the appeal himself admitted that lordship, the vehicle was duly insured by the company, lordship. And the second thing is that lordship, what is cover note? Regarding this, lordship, I have seen the legal principle and interpretation of the legal term, lordship, which clearly says cover note is a temporary document issued by the authority to provide immediate proof of insurance coverage with full policy document.
where it is stated.
Lordship, I have seen this legal interpretation in the Google lordship regarding this cover note lordship. It says that it is a preliminary document which assures that the vehicle is duly insured by the company. It's a preliminary document which implies that lordship this vehicle is duly insured lordship. And I have done for the record lordship. In
I
record,
agree, I said the
Yes,
same thing.
page
It's a temporary
17 lordship in record. It is that cover note issued dated filed D lordship, page 79. Cover note issued dated 29/3/2010 lordship, and that was valid till 28/3/2011. On that day lordship, the vehicle was duly filed D lordship, page 79. File number D, page 79. It's a cover note issued dated 29/3/2010 lordship. And that was valid till 28/3/2011.
79 and 86 in two places it is there.
And 86, yes,
86.
cover note. So which lordship basically when in usual phenomena when you purchase a vehicle lordship, and nowadays on the day lordship the policy is given lordship. And at that time lordship, when vehicle was during 2010, at that time lordship, the vehicle was handed over and cover note is given. And it is the duty up to the authority and seller. There's a tie with the seller and insurance company who deliver the vehicle as the premium is paid and cover note is given. That implies that the vehicle immediately taken from the dealer lordship. If something happens, the entire liability comes to the.
Decision of Supreme Court on this point.
Yes, sir.
But your Google search will not do.
Yes, sir. But from the record itself says that the vehicle is duly insured by the company lordship. Now, my friend has come with
They have
a
admitted.
lordship. They have admitted lordship.
Where?
My lordship kindly speak page 3 of the
Page?
page 3 of the appeal petition lordship.
It's free of the.
Last year. No, page 3.
Paragraph number?
Lordship, just paragraph number page 3, that is paragraph number 1 lordship. Page number 3, last 2-3 line lordship. The respondent number 2 and 3 are the owner and driver of the vehicle. Number so and so which was insured by the appellant lordship.
That is the version of the claimant. I have reproduced that.
That cannot be the denial lordship at the and
Version of the claimant. That's the fact is reproduced before the court.
lordship only see lordship.
So,
Lordship.
Goswami, this is your memo of it.
Yes.
Lordship is true.
Huh?
Lordship,
And-
this normally the facts of the cases reproduced here. Grounds I take different.
And lordship also lordship.
That's what the court has, this is the facts of the case.
Page,
grounds.
page 13 of the judgment lordship.
No, no,
Page
Mr. Goswami,
11.
we cannot read separately the ground taken in the
Yeah,
memo of appeal and the body of the memo of appeal. Both are to be read together.
This is as normally right as reproduced by the claimant, unless
Lordship, page 11 also, Lordship.
this particular expression was missing here.
Page 11,
The fact as per the version of the claimant, because the court should know what is the case. Courts they have appealed the case. If I start writing my opinions in this particular paragraph, it will not be a reproduction of facts of the case.
But once
This is the case. My grounds are different. If I start giving my opinions in this case, particular paragraph, it will not reflect the facts of the case.
and I want to take a Lordship,
I produce the facts of the case as it is.
page 11, Lordship, judgment part, Lordship, page 11, paragraph
My
10.
my own opinions are not there.
For a moment, Lordship, page 11, paragraph 13 of the judgment, Lordship. Lordship, got it? Page 11, paragraph 13, made it, Lordship. Now it is to be determined who amongst the opposite parties will have to satisfy the award. The opposite party number, that is United Insurance Company Limited, in order to rezone its liability, examine one DW named Sri Amitava Madak, who is a senior assistant of United India Insurance Company Limited, Walpara branch, in order to prove that the offending vehicle was not insured with them. DW Sri Amitav Madak, in his evidence, stated that Mr. J.K. Jain, Divisional Manager, United Insurance Co. Limited, Ahmedabad, informed that their Genesis system has not been showing any insurance policy for the cover note so and so dated nil of the vehicle under registration number so and so, engine number so and so, owned by Nazimul Haq. He, in his evidence, stated that no insurance policy was issued on the basis of the aforesaid cover note, but the DW Sri Amitabh Madhav nowhere in his evidence denied insurance of the cover note so and so by the opposite party number 1 International Company Limited. The insurer of the vehicle bearing so and so, he in his evidence only stated that no insurance policy was issued on the basis of the aforesaid cover note. As per provision of the section so and so, the cover note issued against the vehicle had the same value and effect of an insurance policy issued insuring vehicle. Hence, I am of the view that the opposite party number 1 United Insurance Company will satisfy the award. Now, also in their evidence, their officials, they in their evidence stated and denied lordship. From this judgment, it is clearly reflect that the cover note is the on the initial document which reflect that which judgment? The trial court judgment lordship.
It provided in the section for 147.
Yes, lordship.
Okay.
As per section 1, a cover note issued against a vehicle has the same value and effect of an insurance policy issued during the vehicle, insuring the vehicle.
It's stated in section.
Yes, lordship. I have not taken that, but it was judgment I am saying, lordship. I don't have the book. That's
What is the
it is okay. Well,
No, no, section गुली बोले
147. Judgment to that.
1 के
427. April. April. 148. April.
okay.
April. Policy.
Yes, subsection 5.
147.
Subsection 5.
Yes, sir.
It could be followed by, it says it should be followed by policy of insurance. If it is not done, then that should be notified. It's not synonymous. It says that it is a way, but I have already admitted, Lord, sir, I have admitted that part. I'm not trying to suppress my weakness or drawbacks in this case. Only thing is that the owner of the vehicle, I don't know what stopped him from coming to the court. Now he is presenting it. But he could have very well clarified all this matter before the tribunal. I have this policy, this is the premium I have paid, this is a receipt I have got for the premium. That all this could have been done by the owner also. He did not do it. Now it says that, I just like to clarify for my, it's not the same thing as the policy. Command is just one simple document with probably a few words in it. Policy is one which complete rights, liabilities, terms and conditions are there. They are not synonymous documents. It should be followed by. If it is not followed, then there should be a notification that we cannot issue the policy against it.
Okay.
So I have my drawbacks. I am admitting my drawbacks. But at the same time, Lordship, this message to the owners should also go that they have a duty.
You have what?
My lord, I am the claimant, my lord.
Claimant.
Yes, my lord, I have a small submission, my lord. My lord, kindly see paragraph 11 of the, my lord, judgment, my lord. On the careful execution of the medical advice slip and cash memo submitted by the claimant as mentioned here and above, it is found that the claimant had incurred an expenditure of rupees 6,000 towards her medical treatment as medical expenditure. As the claimant has undergone treatment as outdoor patients at Lokshipur PS and Florence Hospital, Golgara, certainly the claimant had incurred some expenditure towards convenience, maintaining attendance, etc. For the claimant, and therefore the claimant side is entitled to the sum amount of pecuniary damages as incident expenditure, as the claimant has a substantial facts are left remark. So I am of the opinion that the claimant is entitled to some amount. My lord, the calculation kindly see, my lord, the page 12, paragraph 12, my lord. Calculation medical expenditure added, my lord, only 600, my lord, instead of 6,000, my lord.
Okay.
My lord, he
That
has
should be,
not.
my lord.
If he had any grievance on that, he should have lost the other. I'm not.
Cross objection.
There's
has
no
not
cross
filed-
objection on his part. I'm not ready to answer his questions now.
No, you were not ready.
Yeah.
But this court is under obligation to assess the actual.
I understand,
compensation.
Lordship. In that case, I cannot be taken by surprise, Lordship. He raises this now at the time of hearing. Lordship, there's a question of natural principles of natural justice. I cannot be taken by surprise. So long he has not given any indication that he is aggrieved by this particular part. This procedural CPC is very fair, Lordship. Fair means he let him get it if he deserves it. But let him also allow me to argue on this, Lordship. Or produce the Lordship. It's a
No, Mr. Kusami, just you see the calculation.
no, I can see, Lordship, but
Instead of 6,000, the court below has calculated it. as
Only 600 added.
six. Let me just.
6,000 to equivalent to
Yes,
600.
this can be done. 6,600.
Yeah.
This particular typography, this can be yes. This can be considered.
And my
But
lord,
I thought if he was trying to increase, otherwise I'll be
No,
taken by surprise.
No, even
This,
then,
this can be taken care of.
Mr. Kusami, even then, in
Even- I-
absence of his such pair,
Hmm.
the court has to assess the actual compensation.
In that case, Lordship, others had got a fair notice that, okay, I'm really going to raise this point. There are several decisions to the Supreme Court saying that there are plus and minus decisions on both sides, that why it's necessary.
on the other hand, my
The
lord,
other said, I cannot be taken by surprise suddenly at the last minute. I should get this much more.
Or Mr. Kusami,
other hand, my lord, interest part may be enhanced, my lord. My lord,
I-
only 6%, my lord, at that time in the.
My opinion, Lordship, how can he go on asking for?
My lord, 25, my lord. So, my lord, this, my lord, interest part may be enhanced, my lord. It's,
Yes.
my lord, 4, my lord.
If he
now
wanted
it's
more, Lordship, he
60.
should have come on an appeal, not take advantage of my appeal to enhance it. That is not fair at all. Lordship. I have objected to his claims, Lordship. I should get if he has a separate claim, I should be ready to answer it. I should get a chance to answer it. Please try to understand. It is not fair.
You take me at the last minute, interest should be incurred.
My lord, due to pendency of this appeal, my lord, I am suffering, my lord, and the amount, even my lord, no amount has been paid till date, my lord. Even my lord, admission of appeal on at least my lord, 50%
Whatever you are
should-
getting it
should be
interest. If it was not paid, you'll getting it, that
paid, my lord. In this
takes
case-
care of the delay, but to ask for, in my appeal, there not be any appeal otherwise.
I leave appeal, your lordship, my lord.
I don't think it's fair, Lord. It's not at all fair.
Court has the
Tell
full
it.
power, my lord.
It's not
Sorry,
fair.
your
A
time.
Hussain, my lord. A Hussain, for
A
claimant.
It's not fair.
For the respondent number,
No, I am for resident number one, my lord.
respondent number.
Claimant.
Sir,
As you answered for two.
as you asked for respondent number 2, are going to consider just a major.
Item number 20.
Judgment period. Judgment is published.
At our last occasion also, there was a direction to obtain the status report, Lordship.
Status report in respect of
CID,
ES case.
yes, Lord.
What is the present status?
Lordship may kindly, come to last page, Lordship, of the instruction, Lordship. Fourteen and 15, correct, Lord.
So investigation is not in progress.
Yes, Lordship. Because the required file was not available at the department office, Lordship.
So, who is for elementary education department? Where is the file?
Today I prepared my lord, a file with my lord, comment my lord, and your lordship also asked some of which memorandum dated 24/2/2005. That was that was also not received from the director of it. So that's how I also talked with my lord, I comment my lord, they started my lord and asked for some recommendation. So that it takes it.
Sir, you see, the matter is further matter with the
My lord,
September.
or lordship, if they have annex one judgment by this coordinate fence, my lord. So lordship, in that my lord, maybe lordship may dispose of that
For filing of appropriate applications to water department.
before that report.
Similarly situated persons are doing also.
Okay.
That may also help the law. At this stage, actually, lots of matters regarding this 2005 regularizations are pending before this honorable court. In other, means time to time they are listed and they are government in some cases file affidavit, they are yet to file. So in that way, the judgment we have placed.
Where is that judgment?
Find that.
Pair number 11.
Yes, your lordship. Accordingly, we are of the view that it would be a fit case for the petitioner to make individual representations before the Secretary to the Government of Assam in Elementary Education Department, enclosing all such documents, testimonials that they may have to substantiate that their names were also included in the list of 2776 numbers of teachers referred in the order dated 9/8/2005. If the petitioners in their individual representation can satisfy the said aspect, a further examination would be required as to whether they are still working as to entitle them to salary and allowances. And upon undertaking such an endeavor, a reasoned order be passed by the authorities on the individual representations that would be submitted. The reasoned order may be passed within a period of 30 days from the date of receipt of the certified copy of the order, and the authorities would be under obligation to pass the reasoned order only in respect of those petitioners who submit their representation pursuant to this order. If the representations are not submitted, no further obligations shall remain with the authorities to pass any such order. Pursuant to the orders dated 9/8/2005 and 28/2005, if the persons whose names are included in the list referred in therein are required to be subjected to any further process, the petitioner shall be subject to such process. If their names are also included in the said list, but in either view of the matter, the representations that may be submitted be brought to its logical end by passing a reasoned order in the manner as indicated above.
Okay, then passing similar direction, we can dispose of it. Madam,
Yes, your lordship.
you have no objection.
No, I do.
Right.